out of station, and Lordship may kindly fix the matter for Monday. It was mentioned for tomorrow, Lordship, but has been listed today. The council could not come.
43 on the request made on behalf of the council for the
Petitioner,
petition
I've informed the others.
stands deferred to be listed on Monday.
Highly object.
As
Monday.
prayed for.
Let the matter be listed next to each other. Both the cases are contempt. It was might
Contempt.
be listed after 4 weeks, but it was a case of 2025.
Oh.
In today, it is not listed.
Right.
29, my lord.
29.
Yes, or 26.
29.
Okay.
May I please? Right, was 50 minutes. The Mr. A. Deka, but he's supposed to do that, but he's suffering from illness. Can it be taken up next week?
Item number
50 minutes. It's a hearing for
50.
Yes, ma'am.
M50, a request is made on behalf of Mr. A. Deka that is indisposed. The matter stands deferred. Let it come in part 2 hearing list. It's a hearing matter. The part 2 hearing, next part 2 hearing list. Yes.
May I please, Lordship, with the function of other party, I beg to mention item number 52.
52.
Can we adjourn the matter for 3 weeks,
52. Same request and prayer is made. You are for the petitioner.
Thank you.
Matter stands deferred to be listed in the part 2 hearing list.
Yeah, I want to make a mention for listing a matter. It was listed in December 2025, and thereafter it has not been listed for admission.
It be on 17th August,
It will be earlier.
12th.
Please, Your Lordship. With the consent of the other side, mention item number 51 of the daily dispatch. In this conference, the some person legal is unable to have the hearing to the item.
51 also. First made on behalf of Mr. Archon stand deferred to be listed in the part 2 hearing list.
May I please, Your Lordship? Your Lordship, I beg to mention WPC 1350 by 2020 for listing of this.
Listing.
Earlier, it was listed on 30/10/2025.
14th August. 14 August.
Please wait, the Lordship. Lordship, I beg to mention item number 37. We have already approached the registry to withdraw our name from the Vakar Nama, Your Lordship. We have lost contact with the client. Kindly ignore the matter.
You filed it before the registry. Have you filed it?
Yes, Your Lordship. We have already approached the registry.
You have filed your application.
We submit our application. Submit our application.
You are submitting your application today. Item 37. The request made on behalf of the council for petition stands deferred to be listed.
Yeah, please. Lordship, I'm praying for listing a matter for withdrawal. Lordship.
Withdraw. Monday.
I'll not be able tomorrow.
Tomorrow.
Okay. May I please? Not, I beg to mention item number 39. In this case, not the higher education not is supposed to file their affidavit, but they have not filed. And without their affidavit, hearing will not be here. So a date may be given and they may be directed to file in the meantime the affidavit.
The matter should be called up. Why are you making a mention now?
Might.
Let the matter be called up.
I'm
Yeah.
I believe the Lordship. I have to mention for listing on contempt petition, Lordship, on Monday, Lordship. Matters listening to area salary and cards.
5th of August.
Lordship, can we add?
No, 5th.
How much?
Submissions made by Mr. Paul Oscar, council petitioner. Why are you withdrawing it?
It's become in fact.
That's the petition. Petition stands dismissed. As in fractures, interim orders stand located, pending higher also dismissed.
Deeply.
MSP Das for the secondary education.
Deeply.
May I pray for deferring this matter for some time, Lordship, because on similar issue, Lordship, one hearing took place day before yesterday before the division bench. Therein the judgment is pending. Therein, Lordship, the judgment passed by the Supreme Court has been considered. And I made submission also there, Lord.
Which judgment passed by?
That you can do for us. Sir. Basically, they are relying upon that judgment.
There is judgment. That will be binding.
My lord. Already there is a judgment of the Supreme Court for 2007, my lord. That has not been implemented. I am for only for implementation of that.
No. This is not a petition for implementation of the earlier judgment, Lord. Herein, they have challenged the notification of 2012.
There already I have, my lord, drawn.
Can a petition be filed, Lord, say for implementation of an earlier judgment, Lord? This is not an executing court.
There is a contempt also.
Yes. Contempt was filed in the year, 2025, Lord. For for alleging non-compliance of a judgment passed in 2007. That is not even maintainable, Lord.
What is the issue with the division bench?
Lordship, in the division bench also, Lordship, similar petitions were filed by some petitioner who were appointed prior to 1/4/1993. Some widows of some workers employees are also there. They are paying.
Matter has been heard.
Yes, the day before yesterday.
Reserved.
Probably Monday or day after next week it's likely to.
Number of occasions, they are just taking time on history or other matter. I don't know why this matter is being deferred by the matter. But there is direction of Supreme Court to correct the names of the petitioners in the approved list. Their names are there in the approved list, only the spelling mistakes were there.
No, their names were not there in the approved list. Lordship, that I have produced yesterday, Lord.
Approved list, they have.
Now, on the basis of their own documents, Lordship, I have produced that their names were forwarded only up to 2006.
I have submitted, annexed this approval letter, my lord, of 2017. They have stated that our names were approved. And
Nowhere that statement is
They are
there. Nowhere.
that, my lord, that.
All right, we'll hear the matter again. 6th of August.
Lordship.
6th August.
Lordship.
Should we observe that no further time may be granted, my.
This submission is made out by the United States. That matter is heard. Similar issues are involved. Hearing submits that this matter will be heard so that this before this court. Mr. Rai so here on the other end submits. The matter has been heard on several occasions. Needs to be disposed of by passing appropriate, considering the submissions made in the bar. State on 6th, just made clear that an attempt will be made to dispose of the matter, pieces of material which are placed or available.
I am on behalf of PK Das person. He is a Shiksha ka discipline. But he put up term. I will take next day.
Request is made on behalf of the council of petition. Able to come to the court. Submit that. Instead after 1
Next
week.
week, that's it. Next week.
Huh?
Next week, any day.
Instead after 1. Council to the respondent will be next week.
Okay.
Item number 4, my lord, although there are two IS filed for paying for vacation of the interim, one by the state and one by the private respondent, there was an understanding that the main matter will. In fact, it was on the submission of the Learned Advocate General.
What are these matters?
The facts are slightly level.
It was not heard before any bench.
No.
Yes.
And may I place the facts, my lord?
Yes.
Slightly longish facts. What has happened is the petitioners before your lordships were all appointed as assistant teachers on contractual basis way back in the year 2012, 2013. And this was pursuant to an advertisement. And now they are all serving as in-charge headmaster. Facts are like this, my lord. If your lordship will kindly take up the writ petition, your lordship will kindly turn to page 39. This is the advertisement. This was issued on 14/2/2012 with a view to support, strengthen and improve the quality of elementary education in the state of Assam. In compliance with the RTA Act 2009, online applications are invited in prescribed format from eligible candidates for the following positions under Assam Sarva Shiksha Abhijan for teachers on contractual basis. Now, if your lordship kindly turns the page, all the districts and number of posts, etc., are given in the chart. If your lordship kindly turns to the next page, your lordship will find in the chart the educational qualifications. And these are, this is not in dispute, these are exactly identical to what is prescribed in the rules for regularly appointed teachers. Now, pursuant to these advertisements, these appointments were made, but on contractual basis. And these people, if your lordship sees page 40, the educational qualifications, even TET qualification is prescribed. TET, B.Ed, etc., for each of the categories, your lordship will find that. So each of these persons are all TET qualified persons. So they fulfill all the other eligibility criteria. But they were appointed as on contractual basis. At this stage, my lord, if I may draw your lordship's attention to the act itself for a moment. The Right of Children to Free and Compulsory Education Act. There's a relevance. That's why I'd like to place this at this stage. Page 246. Under the RTA Act of 2009, your lordship is aware a set of rules have been framed. Now, if your lordship kindly comes to Rule 20 of the rules of 2010.
What are these rules called?
These are Right of Children to Free and Compulsory Education Rules 2010.
Where is it available?
It should be, if your lordship is holding this bare act, it should be there.
Central rules.
Yes. There is a set of central rules also and a state rules also. If your lordship kindly turns to Rule 20, there are two important aspects. The RTA Act, what I'm trying to point out to your lordship is, the RTA Act does not contemplate appointments on contractual basis. Rule 20, sub-rule 1. The central government or the appropriate government or the local authority, as the case may be, shall notify terms and conditions of service and salary and allowances of teachers of schools owned and managed by them in order to create a professional and permanent cadre of teachers. Your lordship, can you mark this?
Yes.
And if your lordship comes to sub-rule 3, the scales of pay and allowances, medical facilities, pension, gratuity, provident fund, and other prescribed benefits of teachers shall be at par for similar qualification, work, and experience. Basically, the whole idea was to create a permanent cadre and to give them all the benefits that normal regular employees entitled. Similar is the provision under the state rules also. If your lordship comes to the state rules,
State rules are available here.
It's in the education manual.
Page number.
In the manual, it's page 241.
40.
And here the only difference is that in the state rules, it is absolutely parliamentary provisions, but it is in rule 18. Your Lordship will find rule 18 at page 265.
Yes.
Sub-rule 1 of rule 18. The government, autonomous council or the local authority, as the case may be, shall notify terms and conditions of service and salary and allowances of teachers in order to create a professional and permanent cadre of teachers.
Parametric.
And sorry,
Parametric provision.
Parametric. And absolutely identical as in sub-rule 3 is sub-rule 3 of rule 18 here. In fact, they use the word regular teachers. In
Yes.
spite of this, they issued the advertisement using the nomenclature contractual. We got appointed. Now, the fact that this was not really for this matter, I'll have to trouble your Lordship. There are two other repetitions where I'm appearing, matter. Item number 32 and 33. If your Lordship kindly takes up WPC number 439 of 24. Item 32. There are two documents that I would like to rely from this. 439. WPC 439 of 2020. Your Lordship will kindly, for implementation of the provisions of the Act of 2009, there is this project approval board, and they held a meeting on 18/3/2013 itself, after the advertisement and these appointments took place. If your Lordship will kindly turn to page 54 of this report.
Yes.
Lordship, at page 54, your Lordship will find the minutes of the 196th PAB meeting. This is the project approval board, full form, held on 18th March 2013 for approval of the annual work plan and budget of Assam. If your Lordship kindly turns over, it's a very long minutes. I'm just placing the relevant portion, which your Lordship will find at page 65.
Yes.
It's right in the middle of page 65, your Lordship will find para 9.3, heading says quality. And this is what was recorded. The state has different appointing authority and procedure of selection of teachers for teacher position borne on state budget and that of SSA. State budget teachers are appointed by the Directorate of Elementary Education and SSA teachers are appointed by the State Project Director. PAB advised the state to address the issue as this will create problems in the redeployment in the schools and advised that all teachers should be recruited by the state government, even if SSA is paying for teachers posts created under the program. So the whole idea was PAB advised that it should be one common cadre. Now, thereafter, my lord, another meeting was held, which your Lordship will find at page 73 of this PAB. This meeting was held on 1/5/2014, right after our appointments. And minutes of the 213th PAB meeting held on 1st May 2014 for approval of the annual work plan budget etc. of Assam. Now, if your lordship comes to page 81, and actually what had happened because of this contractual appointment, two parallel cadres started operating, one appointed by the director, one by the SSA, but for identical work and identical pay scales, etc. So at page 81, para 9.3.1, under right at the bottom one. Para 9.3.1, the heading is teacher's salary. What has been recorded is this. PAP expressed concern over large number of vacancies and advised the state to fill up the vacancies borne on state budget first. Funds for new recruitments under SSA would be approved only when all the state vacancies are filled up. PAP also advised the state to do away with the dual cadre of teachers, as all the teachers belong to the state. The Lordship will kindly note this sentence. All along, it was understood that although the nomenclature used is contractual teachers, it was all along understood that these are employees of the state. Now, thereafter, perhaps in order to implement these directives of the PAB, the Lordship may come back now to WPC 3685, item number 4.
Yes.
Page 56 of this repetition, your Lordship will find that these contractual teachers were given all the identical benefits that the regular teachers are entitled to. They were given, page 56 in the chart, your Lordship will find, they were given a regular scale, medical allowance, dearness allowance, etc. And in the next page, the chart itself shows all the entitlements. And in fact, PF contribution, etc. was also all included. So basically, they have been getting all identical benefits like regular teachers. And if your Lordship kindly, this was in 2013 itself. Now, if your Lordship kindly turns to page 60, this is a communication from the Commissioner Secretary to the Government of Assam in the Education Department, Elementary Education Department, to the Mission Director SSA. And this is what it says. In inviting a reference to the above, I am directed to state that from the beginning, it was decided that the contractual LPUP teachers under SSA will get same benefit of regular teacher under the Directorate of Elementary Education Assam. It is to inform that it is decided that the contractual LPUP teachers get under SSA will get same benefit as that of regular teacher under the Directorate of Elementary Education Assam with effect from so and so. Accordingly, you are requested to extend 7th pay commission benefit to the contractual teachers, etc. So all entitlements like that of regular teacher, and they themselves acknowledge. However, in the intervening period, there was a repetition filed by some of these contractual teachers seeking regularization, and that repetition is in fact still pending. The order passed therein is at page 66. It starts. Relevant portion is at page 69. Third paragraph from bottom at page 69. In that view of the matter, as an interim measure, let proportionate number of posts as the number of petitioners in the elementary education, lower primary government of Assam be kept unfilled, which may not be filled without a legal. So by virtue of this order, there are proportionate number of posts which have been kept. While all this was going on, suddenly in the year 2023, in fact, 10th of January 2023, a move was initiated that your lordship will find we have filed an additional affidavit. Our additional affidavit. Our additional affidavit. Your lordship, there's an additional affidavit filed by us on 27th of June 25. That starts at page 89. If your lordship will kindly turn to page 97. A very strange move was initiated. What it says is this one. With reference to the subjects I cited above, I am directed to enclose here with the model format options for the contractual teachers and the state pool teachers working under Samagra Shiksha Assam, presently working in the elementary schools of the state. The said category of the teachers are to voluntarily opt either for regularization of service with initial scale pay benefits from the proposed date of joining that will be fixed in due course, or to continue as contractual teachers with the existing financial benefits and service conditions. What it was basically saying that we should voluntarily opt for our entire past service being wiped out and re-enter in the regular cadre at the initial stage, or we can continue with the present financial benefits, but only as contractual. This, my lord, is under challenge, which is item number 32, WPC number 439, and here there is an interim protection. If your lordship kindly turns to page 98. Yes. In fact, my lord had the occasion to pass this order. Your lordship kindly turns to page 100. The operative portion is at paragraph 5. As this court had earlier passed an order on 25/1/2024 in WPC number 7223 and other connected matters, and the pending IS that the instructions in the communication that is so and so will not automatically be applicable in respect of those who are rendering their services as contractual teachers under the said teacher, and it is submitted that the petitioners are also suitably situated. It is directed that the petitioners will not be compelled to submit this option in terms of the communication by the timeline fixed, which is 31/24. Now, besides the other grounds, if your lordship comes back to page 97, what is glaringly noticeable is that the government recognizes our right to be regularized. The very fact that they gave us this option is a recognition of our right that we are entitled to be regularized. Only thing that they were, and this was virtually, although the word voluntarily is used, it is virtually directly opposed to the principle laid down in Brajanath Ganguly. We are in this day of unemployment. If we are given such an option, however many times they may use the word voluntarily, we are virtually at gunpoint. But what we are being asked to do is completely forget our past service for the purpose of seniority, promotion, etc., for the purpose of pension, etc. Now, this is the first round of litigation, that is item number 32. Thereafter, my lord, what happened was an advertisement was issued. And that advertisement, your lordship will find in the same additional affidavit at page 101. They are calling this the special recruitment drive, SRD. With a view to support, strengthen, and improve the quality of elementary education in the state of Assam in pursuance of government approval by file number so and so, and in exercise of powers under the so and so rules. Online applications are hereby invited from willing and eligible candidates who are working as contractual and state contractual teachers under SSA through the official website, etc., etc. And it continues, my lord. In the initial pay band, the lordship can notice. So this special recruitment drive is exclusively confined to the contractual teachers. But what they will give us is, in fact, what was the interim protection that was granted in the earlier round when they asked for options. The same thing, they are doing it now indirectly by way of an advertisement. They are giving us the option to come under this recruitment drive. And the prejudice that would be caused, I must indicate, this is also under challenge in item number 33. Now, my lord, we are recruits of 2012. There have been people who have been appointed in 2017, 18, etc. Now, even later points of time. What happens is, if all contractual teachers are treated at par, a person who is appointed 7-8 years after me gets treated equally with me. So unequals clearly being treated equally. So how? Because there are people who have been recruited on contractual basis even thereafter, after us, long after us, 7-8 years after us. So your lordship will look at the situation. I am appointed in 2012. Someone gets appointed hypothetically 2017, 18 or 19, 20. We all come under this advertisement. We all enter at par, at the initial stage. So now a person who has been rendering service below me in the same school, I'll be at par with him. So basically they are wiping out the entire past service. Although the Right to Education Act itself says that the whole idea is to create a permanent cadre. And therefore, it would be deemed that because they followed all the selection procedure, they followed the eligibility conditions that were put, are at par with regular teachers. So there is no difference in the selection process or in the qualification. And in terms of Rule 20 of the Central Act and Rule 18 of the State Act, it would be deemed that we are in the permanent cadre. Now, this advertisement we have challenged in WPC number 4031 of 2024, which is item number 33 before your lordship today.
This is not under challenge in this writ petition.
No. In this writ petition, what has happened is, now after conducting this special recruitment drive, since we have been serving for more than a decade, we have become seniors in various schools. And by virtue of our seniority, we have been allowed to function as in-charge headmaster. Now, by conducting the special recruitment drive, as I pointed out, all the teachers who have been recently appointed under contractual appointment, they are in a beneficial situation. So they applied, they got through. And now, these people are, provisions have been made by virtue of, I'll just indicate, my lord, Annexure 11, 12, and 14, that they will now take over from us.
Where is that?
First is at page 77. This is a SOP issued, page 77. The Director of Elementary Education Assam is in the process of upgrading senior most assistant teachers to the position of head teacher in lower primary schools. District elementary education officers have submitted relevant teacher details for their respective district. Based on these submissions, the Director of Elementary Education Assam has initiated upgradation process. However, during verification, certain complications have arisen that require clear guidelines for school implementation, etc., etc. How they will do the seniority calculation. And at serial number 3, they say exclusion of contractual service. So even for the special recruitment drive teachers, their contractual period will not be counted. But that completely eliminates us without our rights being considered in the previous 2 writ petitions, where there are interim protections. And the next notification is at page 79. Serial number 3. Teachers regularized under the special recruitment drive can become headmasters of LP and UP schools. And then the next impune notification is at page 87. This is the this is not under challenge, right?
Which one?
Page 87.
87.
This is an amendment to the rules. They have defined what is special recruitment drive in rule 2, and in 3, the amendment brought in is this one. Sub rule 10 has been added. The government may, in special circumstances, recruit experienced teachers by a special recruitment drive to recruit regular teachers in the appropriate cadre from the existing contractual teachers and state teachers working under SSA continuously at least for 5 years, whose post shall be personal to the concerned teacher and shall cease with the superannuation of each teacher, and the salary and other emoluments shall be fixed as per ROP and with such other conditions as may be fixed and notified by government from time to time. Now, my lord, broadly, there's an interim protection in this writ petition also, item number 4 also. That is why they have filed these IS for vacating the interim order. Yes. Now, my lord, the it's an order dated 27/6/2025.
Status quo.
Status quo. However, there is one intervening development that I must point out to your lordship. The interim order that was passed in item number 32, that is WBC number 439 of 2024. This was taken to the division bench. A writ appeal was filed by the state, and there is an order by the division bench allowing the state to proceed with the recruitment. That is how they completed the recruitment drive. Okay, continue. Your lordship may come to para 7 of this.
What's an appeal against which order?
This, the option that was granted to us, or I'm sorry, Manu, the advertisement, which was put to challenge, there was an interim order initially. Advertisement itself was stayed. Against that, the state went in appeal. And this is the order passed in the appeal. Relevant portion, your lordship will find at para 7. Having heard the learned counsel for the parties and after going through the materials available on record, as well as the impugned order, we are of the view that the impugned order is a non-speaking order issued without assigning any reasons and without taking into consideration the ramifications which may cause on account of halting the process of selection pursuant to the advertisement in question. Nobody would be benefited if the whole process of the recruitment pursuant to the advertisement in question is halted. However, at the same time, we are conscious of the fact that the contractual teachers are agitating for their rights for regularization and other benefits before this court, and the matter is pending. Hence, in the interest of justice, it is appropriate to allow the state government to continue with the selection process pursuant to the advertisement dated 6/8/24. In such circumstances, the interim order passed by the learned single judge is interfered and the state is allowed to continue with the selection process initiated pursuant to the advertisement dated so and so. However, it is made clear that the selection process pursuant to the said advertisement would not affect the claims of the contractual teachers raised in WPC number so and so and other writ petitions regarding regularization, etc., pending before this court. And the selection pursuant to the advertisement in question would remain subject to the outcome of WPC number 4031 of 24 and other writ petitions filed by the contractor. So, although they were allowed to proceed, it would be subject to outcome of this batch of writ petitions. Now, my lord, on facts, subject to correction by my learned friend, but on facts, this is all there is. Now, the question is,
So now, what is the factual position? Selection is on.
no, they have, for this special recruitment drive, the advertisement that I had pointed out, but after the order in the writ appeal, they have proceeded, some people have been recruited. And naturally, only those people apply who have been appointed recently on contractual basis because they stand to gain. We are the ones appointed more than a decade back. We are the ones who are going to be affected by this. So we didn't participate. There is one group of people who have participated, contractual teachers who have participated and they have been selected. But many of them don't even have the TET qualification. And those people will now take over as like, for example, the private respondents here, I am told are not TET qualified.
This order in the writ appeal is passed in which writ petition?
I'm sorry, Manu.
Order in the writ appeal
Yes,
is passed in which writ petition?
in a connected writ petition, Manu.
What was the order passed there?
There was an interim order. I'll place that now. It was a simply order issuing notice. This is at page 73 of 3685. Page 73 in this writ petition, and your lordship will find the order at page 74. 75 rather.
was the challenge in the writ petition?
The advertisement. So just to make it simpler, one, the first writ petition challenges the option given, where they gave us the option that you opt either for continuing on contractual basis with the present package, or else you come into the regular cadre at the entry level by entirely giving up your past service. So that
This is on the challenge in this particular. writ.
no 439.
What? 430.
That is item number 32. So thereafter, this advertisement was issued. We challenged it in 4031. The advertisement. Initially, there was a stay modified by the division bench,
All right.
and this third writ petition is without adjudication of the first two cases where our rights are involved, and where the division bench has itself observed that these rights need to be adjudicated of, and even the advertisement will be subject to outcome. Now, seeking to oust us from the position of in charge headmasters by persons who are admittedly much junior than us, without adjudication of our rights in the first two cases, that is under challenge in this item number 4.
So the first set of writ petitions where the decision was taken to
Give
oust your, wipe out your services,
If that gets decided,
is that alive today in view of the subsequent subsequent writ petition?
That-
The advertisement is challenged.
that will always be alive, Manoj, because there our right of regularization and whether we are entitled to have our past service counted.
This is already under challenge in the advertisement. That's the whole ground, I suppose.
But these two have in fact merged. These two have in
So
fact,
the challenge made in the first writ petition can also be addressed in the second set of writ petitions when the
fact,
advertisement is
yes.
challenged.
In fact, those two issues, what was said in the first by giving us the option, indirectly that is what they did by issuing the advertisement. So basically, your lordship will have to, the issue that has to be decided is in the present set of facts and circumstances, in the backdrop of the clear statutory provisions.
Now, tell me one thing, the advertisement is issued pursuant to some amendment carried out in the rules.
There's no amendment to the effect that we will issue advertisement, and all it says is, if your lordship has a look at the amendment, what it says is page 87. They have simply defined special recruitment drive, and what they are saying, special recruitment drive means such drive the government may undertake to recruit regular teacher from the existing contractual or state pool teachers under Samagra Shiksha Abhiyan. In fact, if your lordship examines the rules that I placed right at the beginning, there is no question of a further recruitment drive. We have been appointed pursuant to, admittedly, pursuant to a selection process. We have all the necessary qualifications.
And you are appointed as contractual.
The only thing is the nomenclature used is contractual. And this has been time and again that PAB, Project Approval Board, has been time and again right from 2013.
This is a state board.
No, this is a central board.
Central board.
So this is like a monitoring committee for implementation of the RTE Act. Now, they have been saying right from the beginning, right from 2013, that you cannot have two separate cadres. This, in fact, the language used was very categorical. The board directed the state government to do away with the dual cadre. The reason is very simple one. A plain reading of rules 20 of the central rules and rule 18 of the state rules clearly says that it will be, the whole purpose is to create a permanent cadre. And it is for this reason, perhaps, the government strictly adhered to all the principles of selection, including the educational qualifications. In fact, we are better situated than many. so far as the state qualification is concerned. In this backdrop, I'd like to place a couple of judgments. But first, so far as that option is concerned, I am not even troubling your lordship. Your lordship is aware of the law laid down by the Supreme Court in Rosanath Ganguly. You cannot impose upon people in a lesser bargaining position with an unconscionable contract. You cannot make a person sign, accept something at gunpoint. That is the settled proposition. I am just giving the citation, my lord.
You are entitled to trouble us.
In that case, let me place it.
You can give the citation.
1986 3 SCC book list has already been given.
Given.
Please.
Yes.
1986 volume 3 SCC 156. This is that famous Brojanath Ganguly. Very long judgment. I'll just trouble your lordship with the relevant paragraphs. Paragraph 76 and 89.
Read it slowly.
Para 76 reads like this. Under which head would an unconscionable bargain fall? If it falls under the head of undue influence, it would be voidable. But if it falls under the head of being opposed to public policy, it would be void. No case of the type before us appears to have fallen for decision under the law of contracts before any court in India, nor has any case on all fours of a court in any other country been pointed out to us. The word unconscionable is defined in the shorter Oxford dictionary, 3rd edition, etc., etc., when used with reference to actions, etc., as showing no regard for conscience, irreconcilable with what is right or reasonable. An unconscionable bargain would therefore be one which is irreconcilable with what is right or reasonable. Now, para 89. This was for the first time. This principle was borrowed from the English courts. So therefore, at para 89, Supreme Court discusses whether it is time for the Indian courts to adopt this. Now, this is how it reads. It's a slightly longish paragraph. Should then our courts not advance with the times? Should they still continue to cling to outmoded concepts and outworn ideologies? Should we not adjust our thinking caps to match the fashion of the day? Should all jurisprudential development pass us by, leaving us floundering in the sloughs of 19th century's theories? Should the strong be permitted to push the weak to the wall? Should they be allowed to ride roughshod over the weak? Should the courts sit back and watch supinely while the strong trample underfoot the rights of the weak? We have a constitution for our country.
Yes, yes, carry on.
If your lordship wants me to pause,
Yes, carry on.
Our judges are bound by their oaths to uphold the constitution and the laws. The constitution was enacted to secure to all citizens of this country social and economic justice. Article 14 of the constitution guarantees to all persons equality before the law and equal protection of the laws. The principle deducible from the above discussions on this part of the case is in consonance with the right and reason intended to secure social and economic justice and conforms to the mandate of the Great Equality Clause in Article 14. This principle is that the courts will not enforce and will, when called upon to do so, strike down an unfavorable and unreasonable contract or an unfair and unreasonable clause in a contract entered into between parties who are not equal in bargaining power. It is difficult to give an exhaustive list of all bargains of this type. No court can visualize the different situations which can arise in the affairs of men, one can only attempt to give some illustrations. For instance, the above principle will apply where the inequality of bargaining power is the result of the great disparity in the economic strength of the contracting parties. It will apply where the inequality is the result of circumstances, whether of the creation of the parties or not. It will apply to situations in which the weaker party is in a position in which he can obtain goods or services or means of livelihood only upon the terms imposed by the stronger party or go without them. It will also apply where a man has no choice, or rather no meaningful choice, but to give his assent to a contract or to sign on the dotted line in a prescribed or standard form, or to accept a set of rules as part of the contract, however unfair, unreasonable, and unconscionable a clause in that contract or form or rules may be. This principle, however, will not apply where the bargaining power of the contracting parties is equal or almost equal. This principle may not apply where both parties are businessmen and the contract is a commercial transaction. In today's complex world of giant corporations with their vast infrastructure organizations, and with the state through its instrumentalities and agencies entering into almost every branch of industry and commerce, there can be a myriad of situations which result in unfair and unreasonable bargains between parties possessing wholly disproportionate and unequal bargaining power. These cases can neither be enumerated nor fully illustrated. The court must judge each case on its own facts and circumstances. Now, my lord, this principle naturally, since this was the first time the Supreme Court was entering into this arena of unconscionable contracts, the law has developed over a period of time. There were times when arguments were advanced that since the word contract has been repeatedly used in the case of Brajanath Ganguly, it applies only in the realm of contractual law. That myth is also gone now. But here is one judgment where it says that this is Ashok Transport Agency, Government of Orissa versus Ashok Transport Agency, reported in 2002, volume 9 SCC, page 28. This judgment I am placing to point out another development in the realm of this principle. Paragraph 50. Yes. Your Lordship has seen in Brajanath Ganguly at paragraph 76, the Supreme Court says that if, in fact, before placing this judgment, let me just read out that sentence once again. At paragraph 76. What the Supreme Court says in the second sentence is this: if it falls under the head of undue influence, it would be voidable. But if it falls under the head of being opposed to public policy, it would be void. So, taking this a little further, yes, in paragraph 50 of this Ashok Transport case, this is what the Supreme Court says. What is the distinction between void and voidable has been discussed. Thus, the expressions void and voidable have been the subject matter of consideration on innumerable occasions by courts. The expression void has several facets. One type of void acts, transactions, decrees are those which are wholly without jurisdiction, ab initio void. And for avoiding the same, no declaration is necessary. Law does not take any notice of the same, and it can be disregarded even in collateral proceedings or others. Now, my lord, so far as the option that was given to us, this is my submission, my lord. Therefore, based on this principle, and I must inform your lordship that this principle, in case such an argument comes that this is only in the realm of contractual law, this has been applied by our High Court in service jurisprudence. If your lordship so desires, I can place the judgment. In fact, in connection with the education department also.
Yes.
Now, my lord, my second limb of my argument is, you might have used whatever nomenclature, temporary, contractual, ad hoc, it does not matter. statutory mandate is to create a permanent cadre. And being fully conscious of this aspect of the matter, the government deemed it appropriate to follow a very scrupulous selection process. And in fact, they even prescribed TET, B.Ed, etc.
Yes.
So, since we possess all the qualifications, since you adopted a very scrupulous selection procedure, and when this project approval board, which is a monitoring board basically, which has been recognizing this aspect of the matter, all may not be directly, but indirectly, as I pointed out from those two minutes. They said that this what it has resulted in is it has created two different cadres, and it advised the state government to do away with this dual cadre business. Therefore, my lord, the whole action, be it asking for options, because when they asked for options, they are rightly or wrongly, they are recognizing our right of regularization. The question is, having scrupulously followed the procedure established in law so far as the recruitment is concerned, can you simply, by the stroke of a pen, can you simply wipe out our entire past services? It would amount to a violation of an important facet of Article 14. Your Lordship is there. If unequals are being treated equally, here what will happen is someone appointed in 2012, someone appointed in 2019. Both of us simultaneously opt for getting into regular cadre. Both of us enter at the same level. Therefore, it will violate this important facet of Article 14, besides violating Rule 18 of the Assam rules and Rule 20 of the Central rules. Yes. The third limb of my submissions is the statutory mandate as provided in Rule 20 of the Assam rules and Rule 18 of the, Rule 20 of the Central rules and Rule 18 of the Assam rules. Read with the language employed, which are public documents. The language employed by the project approval board in both the minutes. Then read with these two documents. If I may trouble your Lordship once again with these two documents. If your Lordship will kindly come back to page 60 of the writ petition. Yes. The very first paragraph. In inviting a reference to the above, I am directed to state that from the beginning, it was decided that the contractual so teachers under SSA will get same benefit of regular teacher under the Directorate of Elementary Education. It is informed that it is decided that the contractual so teachers under SSA will get same benefit as that of regular teacher under the Director of with effect from so. But the provisions of the rules read with the minutes of the project approval board, read with this document, my submission is that it all along held out a clear and unequivocal promise that we will get the benefit as mandated by the statute. And therefore, having not only by words, also by conduct, having held out such a clear and unequivocal promise, they cannot be allowed to resile from such promise. And I am also invoking the doctrine of promissory estoppel. And I won't trouble your Lordship with too many judgments. I am just placing reliance on MP sugar mills, which your Lordship, I don't think I need to even place it. I'll just give the citation, madam. 1979 2 SCC 409.
Motilal.
Motilal. 79 2 SCC 409, relevant paragraph is paragraph 8. It's a very long paragraph, just to indicate, your lordship may make a note. It's the last about 12 sentences from bottom of paragraph 8. It runs into 3-4 pages at page 425. In fact, that portion, the relevant portion, I can read it out if you want.
This is para.
Para 8. The true principle of promissory estoppel, therefore, seems to be that where one party has, by his words or conduct, made to the other a clear and unequivocal promise which is intended to create legal relations or affect a legal relationship to arise in the future, knowing or intending that it would be acted upon by the other party to whom the promise is made, and it is in fact so acted upon by the other party, the promise would be binding on the party making it, and he would not be entitled to go back upon it if it would be inequitable to allow him to do so, having regard to the dealings which have taken place between the parties, and this would be so irrespective of whether there is any pre-existing relationship between the parties or not. My lord, and here the promise is not just a promise merely by words or conduct. It's a statutory promise. The statute says that it will be a permanent covenant. And it has been recognized by the Project Advisory Board, recognized by the government itself when they say that they are entitled to the same benefit as regular teachers. If they are entitled to the same benefit as regular teachers for all other intents and purposes, can they wipe out that past service? That is the question. Now, my lord, again an argument might come, and although I am not carrying this judgment, again an argument might come that promissory estoppel would operate only in the realm of contracts. That again is gone, my lord, because our High Court itself has time and again applied this doctrine in service law also. There are quite a few judgments. If necessary, I'll place them.
Yes.
The next limb of my argument is, by virtue of each of these, be it the provisions of the rules, be it the Project Advisory Board's recommendations and observations, findings, be it the government's own communications, ultimately recognize my right and this right emerges. Just to give an example, my lord, the authorities gave us the option suddenly, that this was without any advertisement. On 10/1/2023, they gave us the option that you are either opt for regularization or continuous contractual teachers. On 10/1/2023. They didn't say that we will hold a further selection, which means there was a clear recognition of our right to regularization. Now the question is, what is the magic about 10/1/2023 as a date? Why not 10/1/2022? Can it be left to the whims and fancies of the authorities? Why? What is the magic about 10/1/2020? it was only because they recognized our right that they decided that we will regularize. So this right existed in 2012. The right of regularization that the option that they are giving us, this right, when the project advisory board first time told them in 2013, they ought, they ought to have given us that benefit at that stage itself. So what? There is no magic as such about 10.122. This right, as has been recognized in this, that in fact becomes counterproductive in my humble understanding and submission model. That it becomes counterproductive for the government because this is a clear recognition of right. So why not 10.122? Why not 10.121? So this right existed right from the date on which we were appointed because they followed a strict selection procedure which is applicable to my lord, regular teachers. So therefore, my lord, my next limb of my argument is that if it is allowed to be done in the manner in which the state wants to do it, it will amount to taking away my vested and accrued rights. And for that proposition, my lord, I am placing a judgment, my lord, 1997 6 SCC. 97 6 SCC 6 to just one paragraph, two paragraphs, sir. Paragraphs 20 and 24. Seven 6 SCC 623. As my lord got.
Yes.
Para 20. It can therefore be said that a rule which operates in future so as to govern future rights of those already in service cannot be assailed on the ground of retroactivity as being violative of Articles 14 and 16 of the Constitution. But a rule which seeks to reverse from an anterior date a benefit which has been granted or availed of, example, promotion or pay scale, can be assailed as being violative of Articles 14 and 16 of the Constitution to the extent it operates retrospectively. This has been further elaborated in para 24. In many of these decisions, the expressions vested rights or accrued rights have been used while striking down the impugned provisions, which have been given retrospective operation so as to have an adverse effect in the matter of promotion, seniority, substantive appointment, etc. of the employees. The said expressions have been used in the context of a right flowing under the relevant rule, which was sought to be altered with effect from an anterior date, and thereby taking away the benefits available under the rule in force at that time. It has been held that such an amendment having retrospective operation which has the effect of taking away a benefit already available to the employee under the existing rule is arbitrary, discriminatory, and violative of the rights guaranteed under Articles 14 and 16 of the Constitution. We are unable to hold that these decisions are not in consonance with the decision. So now, well, here was a right, as I pointed out, that was available to me under the rules. And as I said, having recognized on 10/1/2023, how is it that this right was not available to me on a prior day? So therefore, this is a right that has always vested in me, and it cannot be retrospectively taken. If they wipe out my past service, it will amount to retrospectively taking away everything that has accrued to me during that period.
Yes.
fact, my lord, and again, this is something, but how is past service to be, even in matters of absorption from one department to another, in that famous SI Ruplal's case, even there the past service was directly with counting. SI Ruplal is, my lord, I'm giving the citation. Unfortunately, I'm not carrying it. Suddenly struck me. SI Ruplal. I'll get the citation. But now, this right of regularization, my lord, came to be after Umadevi. It's there. Paragraphs, SI Ruplal is 2000 volume 1 SCC 644. Here I'm not troubling your lordship with the paragraphs are pretty long. Relevant paragraphs are 15 and 16. Here what had happened was a constable serving in Delhi police was taken on deputation by BSF and thereafter subsequently absorbed in BSF. And he was treated to be a fresh appointment and given the initial scale. So there, Supreme Court said that no, he has been serving in the same capacity, although he was in Delhi police, he was rendering service at par with his colleagues in BSF. So you cannot wipe out his past service. So if from one department to another you can give the past service, here is a case where we are in the same department, rendering the same kind of service, having faced the same selection, we are getting the same benefit. And the interesting thing is, Manu,
Yes.
since we have got all the financial benefits, absolutely no prejudice is going to be caused to the state government. It will help us only for the purpose of counting our seniority and maybe some post-retirement benefits. Otherwise, it is not a case where if they counter service from an anterior date, that they will have to part with there will be any financial burden on this. Not a single extra penny will have to be paid.
Yes.
Now, coming towards the end of my submissions, madam, after your lordship is aware, after Umadevi, it ended up creating a lot of confusion, right, from 2006. And many of these states started coming up with arguments that regularization is simply not a method of recruitment. That has since undergone a lot of interpretations by Supreme Court itself. And in fact, one of the recent judgments judgment, if I remember correctly, Jaggo. This is, my lord, 2024 SCC online 3826. And in fact, I have a copy.
You give the citation again.
2024 SCC online SC 3826. Your lordship will kindly come to para 20.
Yes.
This is a judgment I'd like to trouble your lordship a little bit with. Quite a few paragraphs. Para 20 first. it is well established that the decision in Umadevi does not intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions of the state or its instrumentalities. The said judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and humane resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can, over the time, transform what was initially ad hoc or temporary into a scenario demanding fair regularization. In a recent judgment of this court in Vinod Kumar, it was held that procedural formalities cannot be used to deny regularization of service to an employee whose appointment was termed temporary, but has performed the same duties as performed by the regular employee over a considerable period in the capacity of the regular employee. The relevant paras of this judgment have been represented below. The application of the judgment in Umadevi by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the appellants were employed and have continued the service. The reliance on the procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period through continuous service. Their promotion was based on a specific notification for vacancies and the subsequent circular, followed by a selection process involving written tests and interviews, which distinguishes their case from the appointments through backdoor entry as discussed in the case of Umadevi. The judgment in the case of Umadevi also distinguished between irregular and illegal appointments, underscoring the importance of considering certain appointments, even if were not made strictly in accordance with the prescribed rules and procedure, cannot be said to have been made illegally if they had followed the procedures of regular appointments, such as conduct of written examinations or interviews, as in the present case. The High Court placed undue emphasis on the initial level of the appellant's engagements and the outsourcing decision taken after their dismissal. Courts must look beyond the surface levels and consider the realities of employment. Continuous long-term service, indispensable duties, and absence of any malafide or illegalities in their appointments. In that light, refusing regularization simply because their original terms did not explicitly state so, or because an outsourcing policy was belatedly introduced, would be contrary to principles of fairness and equity. The pervasive, para 22, the pervasive misuse of temporary employment contracts as exemplified in this case reflects a broader systemic issue that adversely affects workers' rights and job security. In the private sector, the rise of the gig economy has led to an increase in the precarious employment arrangements, often characterized by lack of benefits, job security, and fair treatment. Such practices have been criticized for exploiting workers and undermining labor standards. Government institutions entrusted with upholding the principles of fairness and justice bear an even greater responsibility to avoid such exploitative employment practices. When public sector entities engage in misuse of temporary contracts, it not only mirrors the detrimental trends observed in the gig economy, but also sets a concerning precedent that can erode the public trust in governmental operations. Now, I'm skipping paragraphs 23 and 24. Paragraph 25 to 27 are important. It is a disconcerting reality that temporary employees, particularly in government institutions, often face multifaceted forms of exploitation. While the foundational purpose of temporary contracts may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligations owed to employees. These practices manifest in several ways. Misuse of temporary labels. Employees engaged for work that is essential, recurring, and integral to the functioning of an institution are often labeled as temporary or contractual, even when their roles mirror those of regular employees. This sentence is very important. Here, my lord, we have been labeled as contractual. However, the advertisement itself, original advertisement itself says that it is under the RTA Act of 2009, and the rules framed thereunder talks about mandates creating of a permanent card. So they make use of our services exactly like regular employees. They give us the label of contractual employees and exploit us. Will your lordships permit that? That is what the Supreme Court says, that your lordships will not. I am skipping the rest of the portion because this was a case where they were terminated. Here we have not been terminated yet. So therefore I am skipping this portion. Your lordship will come to para 26.
Yes.
While the judgment in Umadevi sought to curtail the practice of backdoor entries and ensure appointments adhered to constitutional principles, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claims of long-serving employees. This judgment aimed to distinguish between illegal and irregular appointments. It categorically held that employees in the irregular appointments who were engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of employees, even in cases where their appointments are not illegal, but merely lack adherence to procedural formality. Pausing here for a moment, my lord, we do not even fall in this second category. In our case, they held a regular selection, issued an advertisement, held a regular selection, qualifications exactly like regular employees. They accept that we should be treated at par. That is why they give us all the benefits of regular, except the benefit of regularization. Government departments often cite the judgment in Umadevi to argue that no vested right to
They are
regularization
giving you benefits of regularization, but without past services.
without past. But that what that does, it does indirectly what they could not have done directly. My past service gives me one very important thing. It gives me seniority. For future, it has an effect. My past service might give me a few thousand rupees more at the time of my retirement. That's very serious prejudice, and your lordship is aware. Supreme Court has time and again held that retirement benefits cannot be treated to be a bounty. So, by doing this, they are seeking to do indirectly what they otherwise cannot do directly, which is not permissible. Now, para 27. In light of these considerations, in our opinion, it is imperative for government departments to lead by example in providing fair and stable employment. Engaging workers on a temporary basis for extended periods, especially when their roles are integral to the organization's functioning, not only contravenes international labor standards, but also exposes the organization to legal challenges and undermines employee morale. By ensuring fair employment practices, government institutions can reduce the burden of unnecessary litigation, promote job security, and uphold the principles of justice and fairness that they are meant to embody. This approach aligns with international standards and sets a positive precedent for the private sector to follow, thereby contributing to the overall betterment of labor practices in the country. So this Jaggo judgment clarifies Umadevi's position, and in fact, following this trend, there is a very recent division bench judgment. Our High Court. But, same thing has been said. So for the sake of brevity, I'll just indicate the paragraphs. Almost identical view has been taken like in Jaggo. Relevant paragraphs are 58, 65 to 67, and 91 to 94. In fact, although in a slightly different context,
Yes.
there was a person who was employed in a 26 Otherwise, these two judgments would suffice, but this is a very interesting judgment. While going through some judgments, I discovered this. This spirit of this judgment, 2022, volume 6, SCC 346. The cause of action was slightly different, but otherwise the facts are very similar. He was
What is the citation again?
2022, volume 6, SCC 346.
Is the name of the party?
K. Raghupati versus State of Uttar Pradesh. Here also, the person faced the selection, was appointed on a contractual basis, and he continued over a period of time. But all of a sudden, and all benefits were given, like in our case. But suddenly, he was summarily terminated. The Supreme Court, applying the principles of pertaining to this Jaggo and other judgments. If your lordship will first come to just for the facts, para 2. It's not a very long judgment. Para 2. The facts in brief giving rise to the present appeal are as under. In response to the advertisement issued by the respondent number 3, the appellant had applied to the post of senior scientific officer. After undergoing due selection process, the appellant came to be selected and appointed as senior scientific officer on contractual basis in the said university by its order dated 3/8/2011. The said appointment was initially for a period of 2 years. The appellant's services were extended for another period of 1 year by the said university and by its order dated 7/8/2013. However, by communication of the said university dated 12/8/2014, the appellant was informed that the period of his contractual appointment had expired on 11/8/2014 and he was directed to complete the formalities regarding relieving from service. These are the facts. Then, when the matter went to the court, this is the affidavit that was filed, that is recorded in paragraph 8. There are 2-3 paragraphs of that affidavit which are important. Para 8.
Yes.
It will be apposite to refer to the relevant part of the supplementary counter affidavit filed by the filed on behalf of the university before the High Court of Judicature at Allahabad. So, Lordship may skip the paragraph 5 and 6. Your Lordship may come to the para 7 of that affidavit. That it is also necessary to clarify at this stage that even though the university is appointing its employees on contractual basis, the method of selection and thereafter appointment of these employees is the same as that which is followed in the case of regular appointment of its employees. Next, that for every post which is vacant and which is proposed to be filled up, the university publishes an open advertisement inviting applications from all interested candidates. Applications so received are then placed before a duly constituted selection committee, which holds interviews of the applicants' candidates for the various posts. It is on the basis of the recommendations made by the duly constituted selection committee that appointment letters appointing the employees on contractual basis are issued by the university. Next, para 9. That these employees, though technically appointed on contract, get all benefits, allowances as per the rules applicable. They are placed in a regular pay scale and extended annual increments, leaves, EPF, GPF, deductions, contributions, and other benefits. But for permanency and tenure, their terms and conditions of appointment are identical to those of any regularly appointed candidate. So everything else is the same. And in this context, what the Supreme Court holds is at paragraph 14 and 15, the conclusion. It could thus be seen that though the communication of the said university dated 12 May 2014 states that the appellant's contractual service has expired, in the facts of the present case, it would reveal that his services were discontinued on account of the allegation made against him by the dean of the said university. Since even according to the said university, though the employment was contractual, but the employee was entitled to get all benefits of a regular employee, we find that in the facts of the present case, the appellant's services could not have been terminated without following the principles of natural justice. We therefore find that the present appeal deserves to be allowed on this short ground. In the result, the impugned order dated so-and-so passed by the High Court of Judicature so-and-so, thereby dismissing the writ petition filed by the appellant and the communication passed by the said university dated so-and-so, thereby discontinuing the services of the appellant are quashed, etc. So, considering the facts of the similarity in the nature of the job, nature of selection with regular employee, the Supreme Court treated him like a regular employee and therefore it was set aside. Although he was a contractual employee and he had served only for 3 years. Here, we have served for 14 years. So,
Yes, you did not place the judgment, division bench judgment.
your lordship wants to tackle this.
Yes.
Division bench judgment, para 58.
What are the facts? What are the facts?
The facts are at para 2. Para 2 are the facts. The appellants were appointed as grade 4 employees in the year 2004-5 against substantive vacancies under Joint Director Health Services also. They continued to serve until the services were terminated in 2009. That's all.
Yes.
This context, paragraph 58 onward. Again, Uma Devi is discussed. The reliance placed on Uma Devi must be understood. Para 58, in fact, my juniors, for some reason, perhaps it is a long judgment. The whole judgment perhaps has not been. Para 58. The reliance placed on Uma Devi must be understood in its full constitutional setting. The Constitution Bench was addressing a phenomenon that threatened the integrity of the public employment itself. The proliferation of ad hoc, temporary, and backdoor appointments as a substitute for regular appointments. The judgment is animated by the need to restore fidelity to Articles 14 and 16 of the Constitution of India by ensuring that public posts are filled through an open, competitive process. At the same time, the court was acutely conscious that a rigid application of principles could produce grave injustice in individual cases. It therefore drew a vital distinction between appointments that are illegal in the sense of being fundamentally contrary to the constitutional scheme and appointments that are irregular due to deviations in procedure. The former, the court held, cannot be protected. The latter may, depending on circumstances, invite equitable consideration. Now, my lord, your lordship must keep on to para 65. 65 to 67 are relevant. As my lord, in the present cases, the appellants did not enter into service through a concealed or surreptitious route. Their entry resulted from a recruitment process initiated by the state itself. Advertisements were issued in the public domain. Applications were invited. Selections were held. Appointment orders were issued. And the appellants were inducted into service. From that point onwards, the state treated the appellants as members of its workforce, assigned them duties essential to the functioning of public health institutions, and paid them salaries from the government fund. This conduct of the state continued uninterruptedly for nearly 14 years. In public law, such sustained conduct is not devoid of normative significance. It generates a legitimate expectation that the engagement is lawful and stable, and it simultaneously imposes a corresponding obligation on the state to act fairly, reasonably, consistently, and non-arbitrarily. Viewed thus, the appointments of the appellants cannot be characterized as void ab initio. At the highest, they suffer from procedural irregularities attributable solely to the employer. That does not even exist in our case. Such irregularity does not erase the reality of long and continuous service rendered, nor does it neutralize the equities that have crystallized over time. Then what is public law, etc. is discussed. Your Lordship may skip this portion. Paragraph 91 to 94. '94. 91. To summarize, the constitutional position that thus emerges is clear and admits of little ambiguity. Where appointments to public posts are made pursuant to public advertisements and the recruitment process initiated by the state against existing vacancies, and the appointees have served for long and uninterrupted periods without any allegation of fraud or misrepresentation, such appointments cannot be treated as nullities merely on account of administrative or procedural lapses attributable to the employer. After the extraction of a prolonged service, the state is constitutionally restrained from undoing its own acts to the grave detriment of the employees situated at the lowest ranks of service. More particularly, when there is no allegation of fraud or manipulation and admittedly appointments were made after a selection process. For the aforesaid reasons, we are unable to sustain the action of the state government and so and so. The appeals are accordingly allowed. The common judgment and order dated so and so passed by the so and so is interfered. The termination orders are quashed. The appellant shall be reinstated in service with continuity of service for all notional purposes. So here is the case. The division bench has directed not only reinstatement, continuity, which means right from the beginning.
Yes.
So those are the, my lord, legal submissions. Just one thing that I had omitted, I wanted to leave it for the last. What will be the prejudices that will be caused to us? Caused to us if we are treated to be fresh. Most importantly, my lord, my seniority and promotion avenues for future. I will come at par with people who were treated as contractual appointees much after me. So now I would stand in the same footing. That is number one. And the second most important thing that I will lose out is, in the meantime, my specific instruction is that since 2012, 13, 14, we have received 10 increments. So that gets completely wiped if I am treated at the initial. Those 10 increments go, my prospects of seniority goes, and the benefits that would accrue to me at the time of retirement. The Lordship is aware of there are multiple areas which depend on my length of service. Earned leave, encashment, P1. So benefits that would have otherwise accrued to me had my past service been counted. So far as the prejudices are concerned, these are the threefold prejudices that I would face. Therefore, my lord,
You're still serving.
yes, yes. In fact, my lord, they recognize should be virtually, my lord, in the context of the law as has been laid out by the Supreme Court and as it prevails today, it would be wholly, my lord, impermissible for them to treat me in any other way but for the way that I have placed. That is my humble submission, my lord. That option business has to go. Advertisement, since they have already carried it forward, they have taken it to their logical end.
What was the position when you were appointed initially?
I'm sorry, my lord.
What was the position when you were appointed initially?
Contractual.
Were there other regular employees
Yes.
also working?
Yeah. So now, if I am treated to be of 2012, any regular appointee appointed in 2011 would be above me. Anyone appointed in 2013 would be below. That would at least give me some hope of some career progression. That would give me, if not career progression, at least these 10 increments I will not lose. At least some benefits, additional benefits at the time of my retirement. In fact, there is one statement which my friend has just brought to my notice. There is one IA that has been filed. Apparently, that is also in the list. We have annexed that. If your lordship will kindly have 4031. 4031 item number 1. Item number 33. 4031.
4031, yes, we have it.
If your lordship will kindly take up one, the writ petition, there we have annexed an affidavit filed by the government in WPC number, in a IA filed in WPC number 8824. Your lordship will find that at page 147.
Yes.
147. This affidavit we have annexed. This IA is this IA is item number 5 of today's list. And this is what they say at paragraph page 149.
Yes.
At page 149, line about 12 from bottom, somewhere in the middle, there is a sentence starting in this regard. In this regard, it is stated that considering the huge number of 35,327 contractual teachers involved, the entire exercise is to assess the financial and other implication based on the number of options available, and no decision has yet been taken till date for regularization. As regards fixation of pay at the initial stage in the event of regularization, in the humble submission of the answering respondent, since the petitioners were born into contractual service condition, therefore altering service conditions of the initial stage at a subsequent stage by way of regularization may be contradictory in nature. Then next paragraph, even more interesting. Paragraph 5. That the answering respondent humbly begs to submit that the exercise to figure out the financial and other implications in the event of regularization of contractual employees as stated above is just an academic exercise. So they are saying that the reason they were taking options was an academic exercise.
So why this IA was filed?
This was perhaps for
challenging the option.
this IA is filed by someone else, man. I'm not aware. Just we brought this affidavit on record. I am not appearing in that matter. We brought this affidavit. Once we saw the contents, we brought this on record. The fact remains that they will not entail any additional financial burden, except maybe for a few thousand rupees extra at the time when I retire. Otherwise, because they have been giving me all the increments, regular scale at par with the regular appointees. Therefore, Malan, looked at from any angle, if I have understood the facts and the law correctly, this writ petition deserves, all three of the writ petitions deserve to be allowed. so far as what they have done with this, since the, so far as the advertisement is concerned, some of the contractual teachers, they have voluntarily applied. So we can't have any say on their fate, which means they have effectively given up their rights of claiming the passwords. They may not be interested, but so far as we are concerned, we are definitely interested in.
Yes.
Subject to what my current friend says. But your lordship will kindly excuse me for a little while. In the meantime, some cases.
So there are two cases of two different causes of action. One case is lordship, WPC 3685, Junmoni Devi.
This is the case we are hearing, perhaps.
Yes, Lord.
3685.
Yes. In that case, the prayer lordship will see page 36. Have lordship got it? They have challenged the SOP signed on 3/3/2025 and notification dated 29/4/2025, along with subsequent letter dated 5/6/2025. That lordship will find at page 77. They have not placed it. Only just a passing reference about the page number. So this is the court challenge in this writ petition. May I place it, lordship? Because first lordship will have to know what is under challenge. All the judgments are cited, those are absolutely not relevant to our present case, because in our case, there is no case of discontinuation of the contractual employees or rather termination of the contractual employees. That is not the case. Therefore, all the judgment from Jaggu to the judgments which they have cited, lordship, have no relevance to the present list. So may I read it? Standard operating procedure for upgrading senior most assistant teachers to head teachers in lower primary school. The Director of Elementary Education Assam is in the process of upgrading senior most assistant teachers to the position of head teacher in lower primary schools. District elementary education officers have submitted relevant teacher details for their respective districts. Based on these submissions, the Director of Elementary Education Assam has initiated the upgradation process. However, during verification, certain complications have arisen that require clear guidelines for smooth implementation. This standard operating procedure has been developed to resolve these issues and streamline the process. SOP guidelines, seniority calculation. The school-wise seniority of teachers will be considered for upgradation to the post of head teacher. Appointment date of SRD teacher. The teachers recruited under special recruitment route will have their seniority counted from the date of their new appointment under the jurisdiction of the Director of Elementary Education Assam. Exclusion of contractual service. The contractual period of SRD teachers will not be considered for seniority. Resignation undertaken by
Just 1 minute. Just 1 minute.
Lord.
Are you representing all the writ petitions?
No, madam. I'm representing item number 1, 32, 33, 34, 35. So,
Where are the other petitioners? Any other petitioners who would like to address the court?
Because there are multiple causes of action and I have to address everybody.
there are others. We have BD Goswami who's here, madam.
Because before you reply, you must know who
Yes,
is appearing in what.
Exactly, lordship. And I have to, at one go, I want to finish it off.
No other petitioners then will say that these are all covered by these arguments.
But cause of actions are different, lordship. Lordship may pass that order. I have not said that lordship may not pass.
Lordship, there is one order of this in 3685 where lordship where the on the stand of the learned AG that has taken and recorded that regularization and this issue would be decided together. That's why all the
That is fine, because There are some interlinking.
There are different petitioners here.
Yes, my lord.
Who are appearing in the other matters? 6, 7, 8, 9, 5, 6, 7, 8, 9, 10.
They are there.
Are you adopting the arguments of Mr. Chaudhary?
There are learned senior counsels.
Yes,
K.
Mr.
Goswami,
Goswami?
B.D. Goswami, all big shots are there, Lordship.
No, we wanted to know before the state replies, are there going to be any other submissions by any other council or
No,
only
I
one
understand
submission?
essentially, my lord, this case, my lord, although the status is somewhat similar with the petitioners in the ongoing case and the others. This is relating to the stay vacating matter.
So we are hearing the entire matter.
Yes, that is, in fact, I was also under the impression that only the stay vacating will be heard today, but I am agreeing, Lordship has heard extensively. I'll not make any submission that only the stay.
Yeah,
The
hearing
whole
the
case should be
entire matter.
thrashed out.
And slightly, my lord, they can take it up maybe tomorrow or day after, my lord, it's all right. Because the matter has been adjourned.
Then
on
let
some
me-
like
we are not
revision by
required-
only
We are not required to invite members of the bar and put them to notice that we're going for a stay vacating hearing or a final hearing.
No, my lord,
Exhaustive
my lord,
hearing
my
taken
lord,
place.
understanding is this.
Ah,
This matter has been adjourned on account of, my lord, this the first case, my lord.
ah.
Every now and then, my lord, the matter will get listed, my lord, then it will get adjourned. One or the other party, my lord, will take time.
And that is why I'm in deep trouble.
Unfortunately, it did not happen today.
No, exactly.
So what can the court do? Your presumption did not appear to be correct.
That is 100% correct.
Speculation, Lordship.
Speculation.
Speculation.
And our submissions are not going to be very different from what has already been
Therefore, we are
submitted.
asking you, if you adopt the arguments, then he can begin. That's it's the only short question that we.
Then in that case, your lordship will kindly allow, so far as I am concerned, my lord, in my cases, my lord. If necessary, I'll give it.
No, let them complete,
Without
Lordship.
even arguing your matter. That would be expanding the scope. If you want to say something, you can say something, we record it, and then let him reply.
Will be taken up on hearing date.
If not inconvenient on Tuesday, Lordship, because the matter will be afresh in the mind of the court also.
It will be fine.
Tuesday?
28th.
28.
Pending for a long, but
I'm under deep pressure, Lordship, from the department, because whatever way it goes, we have to take a decision regarding upgrading the senior most teacher in the LP schools.
The item number WPC Saimukhi item 3685 of 2025. Mr. Rai Chaudhary, Senior Counsel, assisted by Mr. S.P. Sharma. He appears for the petitioner, Mr. Chaudhary. Argue the matter on behalf of the petitioner. The counsel for the senior counsel for the petitioner has concluded his arguments, reserving his right for a reply. Stop. There. The counsel representing the petitioners in the other matters, connected other matters. Upon a query being asked as to whether they would like to submit before the court or would like to adopt the arguments made by Mr. Chaudhary. There was a request that they would like to address the court, their issues. Accordingly, it's submitted that the matter be continued for hearing on Tuesday, 27th. Mr. Evajit Saikia, Advocate General, Senior Counsel Advocate General for the state of Assam, also representing the state, assisted by Mr. N.J. Karoli. For for further hearing on Tuesday.
Highly
Also, the item number 32 and 33, the senior advocate, I chose. 32, 33.
You've recorded it's only in item number this.
My lord, he had referred to 439 and 40. The 32, 33.
Item number?
32, 33.
No, yes, I address only in this matter, item number 4.
Yes.
Yeah.
The similar matter. That is why my lord, he had read the documents from 439 and 40.
You submitted at the bar. Mr. Rai Chaudhary also appears for item number
32 and 33.
32 and 30. Writ petition number.
Or there's an interim order.
Interim order wherever past will continue.
So,
Stepping to it. Even on- So good.
This one I have challenged the malab in DLC minus as well as SLC and then subsequent appointment of the order of the respondent number 9.
Hmm?
Respondent number 9.
Hmm.
Number 9 malab appeared malab. One is the cause list malab. He also filed affidavit opposition. I also filed reply. Not appeared.
What is the matter here?
That one malab basically malab the appointment on compassionate ground malab. The younger brother of the petitioner appointed malab, though he was a minor malab at the time of application. Secretly malab.
Younger brother of the petitioner.
Petition. The petitioner earlier applied my lord. This honorable court
So it is a
also
fight between brothers.
brother.
This is a matter which should be referred to mediation.
My lord, my lord,
What is there to decide? Fight between brothers.
illegally, major illegally done my lord. Is shown in applied in at the time of minor my lord.
Who represents the private respondent?
YS
you
Mannan,
are-
my lord.
You are a dependent person on of your father, of your late father. So is your brother.
My lord.
So one member of the family is appointed. Why are you questioning it?
But he is now my lord living separately, my lord. I have my lord
Who represents the respondent 9?
YS Mannan. Then shown in the cause list, my lord. My lord.
Respondents, what do you say? Affidavit's fine?
Affidavit filed, my lord.
What is the stand of the respondent affidavit?
Kindly see, my lord, respondent number 9, my lord, page 64.
Hmm?
page 64, my lord,
No, respondent 9 is the private respondent.
private respondent. Respondent
No, no,
number
no,
6 is the,
respondent,
my lord,
sorry, respondent 6,
6 is the, my lord,
DC.
chairman of the DLC, my lord,
DC.
DC, my lord.
What is the,
My lord, page 82, my lord. He stated that, my lord, the application alia submitted on 10/1/2000, my lord, as subsequently, my lord, another application filed, my lord, before the deputy commissioner, my lord, kindly see page 93, my lord. And on that basis, my lord, DLC considered.
so they stated that there is no application from your side,
My lord,
not be traced out.
but my lord, earlier occasion, my lord, I approached before this honorable court, my lord, and this honorable court directed to consider the case of the petitioner, my lord. And thereafter, my lord, kindly see, my lord, page 42. The director of secondary education, my lord, secretary to the government of Assam issued a letter, my lord, where we have forwarded my application to the, my lord, district commissioner, my lord. Page 42. In view of the above, petition is disposed of and limited to the district level committee to consider the matter in accordance with government policy and so and so. View DLC minute, my lord, case page 44, my lord, annex of 12. It stated that my application of the respondent number 9, my lord, on 10/1/2000. 10/1/2000, my lord, he was minor, my lord. Kindly see, my lord, legalia certificate page 26. Issued by the deputy commissioner on, my lord, 28/4/2000, wherein stated that, my lord, he was 16 years old. Second to the DLC meeting, my lord, the mother of the petitioner made a complaint before the, my lord, inspector of schools, my lord. Page 53, my lord. The on person's death, my lord, complaint, my lord, the inspector of school issued a letter to the deputy commissioner. But this was not considered, my lord. And subsequently, my lord, appointment lord, the order was passed.
Oh, but there is an averment that your affidavit, your application was not traced out. Not found. Your brother's application was found.
Initially, my lord, they applied before the, my lord, director of secondary and subsequently, my lord, the secretary limited my application to the deputy commissioner. In the
They
year
have maintained that
2004.
no communication has been received. What is your response to this? Have you filed a reply?
I have filed it. my lord.
What have you stated?
Respondent number, मतलब subsequent application, मतलब the respondent number 9 also filed direct application before the deputy commissioner. Not for the मतलब administrative department. The department should have मतलब forward the application before the मतलब district level committee, मतलब place before the district level committee. मतलब
Find any grounds to interfere.
court on so many occasions मतलब dismiss the मतलब petition मतलब shown in the मतलब the petition of file submitted application at the age of minor मतलब I have annex मतलब 120 मतलब.
No, but your application is not found. Your application, the challenge is made at the behest of a person who has not applied. That is what the position is. Your application is not found.
मतलब there is a communication regarding मतलब forwarding my application to the district level committee.
Where is that?
मतलब
But it was not placed before the SLC.
kindly see मतलब page 43 मतलब. In pursuance of the order of this honorable court मतलब, the secretary forward remitted the matter the DLC मतलब. Of the above, the petition is disposed of, remitted to the district level committee to consider the matter in accordance with the government policies and so.
DLC.
DLC.
Then what happens?
Thereafter, my candidature has not placed before the DLC, and after long span of time, on 23/12/2021, the candidature of the respondent number 9 has been placed, Next at 12, page 44.
Nothing here to suggest that you had applied. Your papers were not available there. Come before the court earlier.
Yeah.
Where? There is a categorical stand of the respondent is that you did not file any application. Your application was not received.
In percent of court order, are limited to the DLC, 4 months. Earlier court order, page 37, page 32, page 37, next up 10. Number 2 is the petition topic of the name. Honorable court order dated 10/1/2004. Disposed directed.
What happened to your sister? Writ petition was filed by your sister also, a wife.
No, sister no, separate
Huh?
Separate
Okay. Two separate persons.
Separate person under the same district What the portion of the order is 40 I have heard a
What
lot of,
happened after that?
after that,
2004.
nothing has been done, Malad, so far as petitioner is concerned, Malad. Deputy Commissioner, Malad, DLC, Malad,
When was your brother's appointment made?
appointment made, Malad, kindly see, Malad, page 15, annexure 15, page 56, Malad. 23rd September 2022.
From 2004, what have you done? Nothing.
There is no, Malad, written communication, but, Malad, so far as my respondent number 9, Malad, he has not filed any, Malad, communication, any, Malad, and Deputy
No,
Commissioner on
the respondent nine's appointment scrutinized, done at whose instance? That a person whose documents are not available. From 2004 to 22, nothing. Should have pursued the matter.
subsequently, Malad, the mother also filed complaint, Malad, stating that, Malad, the original applicant is the, Malad, Prohibitions petitioner, Malad, not the Saifuddin.
Dear respondents,
I am appearing for the secondary education department, and earlier he was filed a writ petition, and where he stated that the petition is instituted on an apprehension that if the respondent number 7 is appointed on a compassionate basis, there is the possibility that he may not maintain his mother and other siblings, although the appointment would be obtained on compassionate ground. As the writ
from where
petition,
are you reading it?
page 63.
63.
Yes. Page 62. WPC 1940/2022 and filed by Safikuddin Ahmed, petitioner. And here, my lord, at the last, it is stated the petitioner is accordingly allowed to withdraw the writ petition. Liberty remains that the petitioner to approach again in the event the apprehension raised in this petition turn into a reality on a subsequent date. Writ petition is filed on an apprehension. We deem it premature at this stage. There was a apprehension regarding that his brother may not maintain his mother and other siblings. So that liberty was given to the petitioner at that time. To if there is such things happen, then he may approach this court matter.
Accordingly, Malad, I
At that time, he was not challenged the appointment of the of his brother.
You did not challenge.
Malad, far as, Malad, I have challenged that appointment, Malad.
But the
it
petition
is
was
not-
withdrawn. It is clear recording by the order.
Subsequently, Malad, your brother has not managed my.
That's a
Yeah,
different.
Saifuddin Ahmed
Then,
also,
then your remedy lies before the authority.
and Saifuddin Ahmed also implemented as respondent number 7 in that writ petition.
Your grievance is that he is not managing, he is not looking after you in spite of being appointed. Grievance is before the authorities. In this writ petition, which was filed, your apprehension is recorded in the order is that that you may not be maintained by the brother.
Another part, but the whole thing is, Malad, the respondent number 9 was legally appointed, Malad.
What is the age of the respondent 9?
9, Malad, at the time of application, Malad, 16 years only.
From where do you say that?
Malad, kindly see, Malad, legal year certificate, Malad, page 26. 66, Malad.
Sajida Begum, Morzina Ahmed, Sofikuddin Ahmed, and Saifuddin Ahmed. The respondent number 9. Son, age malat reflected 16 years. And then malat come to the malat page 45. Page 45 malat.
Do you have any birth certificate or anything?
No malat. I have not malat annex malat. But malat page.
This document is to show who are the DLAs.
Malat.
This is not a document to justify the age of the.
Age is reflected.
No,
malat.
reflected,
Malat,
but it's
16
not a
years.
document to justify the age of the legal age therein. For the age, you have to prepare, you have to take out a birth certificate.
Malat, it is the custodian of the respondent number 9. And page 45 malat stated malat date of filing application 10/1/2000. Second illegality malat the respondent number 9 filed application initially before the malat
But he passed MA.
MA malat now.
His meeting was held on 21.
21 malat.
Oh.
After that DLC meeting malat page 54 malat.
Let Mr. Mannan
Malat.
come here. Why is Mannan called? Take it up at 2 p.m.
Apply.
Yes.
Page number 28 is the arbitration clause of the arbitration text.
What is the objection here?
My lord, the objection is, my lord, there is a, my lord, claim made by the, my lord, petitioner is a, my lord, date claim, my lord. It's, my lord, time bar. So, I am relying on decisions of the Honorable Supreme Court, my lord.
Oh, first tell us the facts.
Yes, facts,
Before you
lordship
go
will,
to the judgment, you tell us the facts.
yes, lordship will find,
Where is the arbitration clause?
Page 28, para 26.
28.
28, para 26.
What is this agreement about?
regarding,
Lordship, this is a development agreement between Sri Atul Chandra Kalita and the respondent Shankardev Real Estate and Developer Private Limited. Sri Atul Chandra Kalita
The landowner.
was the landowner. Now deceased and the case has been preferred by his legal heirs. The respondents had taken his land for development for construction of a residential property. And subsequently, as per the development agreement, they were, it has been stated that he'll be awarded residential flats. But after the execution of this development agreement, and another supplementary agreement has been executed along with a power of attorney. So now the issue here has been, as per the supplementary agreement, they were supposed to give us 2 flats, but now they have been only given possession of 1 flat, and the second flat, the possession has not been handed over to us. That has been the issue right now. And as per the land which we have given, as per the development agreement, we have already handed over the original sale deed to TAM. to them. And during this process, subsequently, Sri Atul Chandra Kalita has already passed away. And because of the non-compliance of the respondent, we had already filed a title suit where the respondent had highlighted that the case to be transferred for arbitration, and the order also has been passed in the year 2018. But since the year 2018, we have only been on the stage of discussions. Only in the year 2025, we had sent notice to them. And after their non-response, we have filed this present petition.
Where is the agreement clause which says that you'll be handed over 2 flats?
A, my lord.
Supplementary.
Clause number, my lord, 2.1 and 2.2.
JK3, I am in possession, which is in the 3rd floor.
This, my lord, with regard to 2.2, my lord. Second party shall allocate to the first party a two-bedded flat being flat number 1 on the first floor at block 2 together with one open car parking space known as Ganga Nivas of the proposed building to be erected on the said premises subject to, my lord, transfer by way of deed of sale together with delivery of physical possessions of the part of the remaining land in favor of the second party, that is the builder. After conceding the portions of the land as relinquished or approach road passes by clause number 5.1 of the principal agreement, the first party further agreed to pay a sum of rupees 2 lakh only to the second party at the time of delivery of possession of flat number G1 as a permanent. The dispute is, my lord, they have not, my lord, executed any sale deed as.
So therefore, go for arbitration.
That's why, my lord. Now lordship will find page 108, my lord. They have earlier approached before the, my lord, Honorable Civil Judge Senior Division number 2 by filing a suit for specific performance of contract. Here lordship will find the cause of actions at page 115, para 20. Got it, my lord. The middle portion, my lord, six line from bottom of the para 20, my lord. Finally, 25/4/15 when the plaintiff demanded, this is the cause of action, my lord. When the plaintiff demanded for specific performance of contract dated so and so. So as per, my lord, pleadings of the, my lord, plain, the cause of actions arose, my lord, on 25/4/2015. Now lordship will find that, my lord, in that case we have filed section 8 petitions, and the honorable trial court, that lordship will find the order dated 29/8/18, page 142. That by this, my lord, order, the trial court has referred the matter to the arbitration. Then, my lord, my submission is, my lord, the, my lord, 29/9/2018, the, my lord, trial court has passed the order, my lord. They have, my lord, not taken any steps till, my lord, 2025 for more than, my lord, 6 years, almost 6 years, my lord. Now, my lord, they have issued a notice, my lord, the cause of actions, my lord, the claim made in the, my lord, suit as well as the
arbitration.
My humble submission, the death claim, my lord, and which is, my lord, absolutely barred by limitation, my lord. They cannot, my lord, go for, my lord, arbitration.
Source limitation
54, my lord. Article 54.
No. The arbitration.
Arbitration, my lord, here is 2 points, my lord. The one point is, my lord, the notice, my lord, when, my lord, issued, and if the approach within the period of, my lord, limitations, that is, my lord, from the date of issue of notice, my lord, they have issued notice within 2025 and approach before this honorable court within line. That is, my lord, I have no objection.
But so far as the my lord claim made in the my lord claim as well as my lord, even if we my lord count from the date of my lord order of the trial court my lord in the year 2018, then also time barred my lord the claim.
Must be within 3 years.
Yes, specific performance of contract.
You're right, the arbitration petition, I've already made a statement that after the passing of the order
Madam.
dated 29/9/2018 in title suit 417, the
Who
legal
filed
hires
the
of,
title suit?
They are fine.
we have get preferred. The legal hires of Atul Chandra Karita were contacted by the respondent with a proposal to amicably settle the matter, but despite prolonged discussions, no settlement could be arrived till date.
This is my
It
lord.
doesn't help you with your limitation. You are aware.
You know, we have been in communication with them, but
You may be in communication, but you have a period of 3 years from the day the dispute arises. Refer it to arbitration. You have as many number of discussions within the limitation, otherwise limitation will never apply. How do you come out of it?
looking for an accommodation today, price discount on the next day. And the date may be fixed, if possible, on 7th. 7th, August. No, October.
Counsel for the petitioner, praise for. Spoke for whatever. Accommodation for the day. For some time, for some days. Has agreed to this matter again on, not 7th, 21st August.
Much of it.
Mr. R. Sharma for the respondent.
Apply.
Where is the counsel? Is not here.
Hello. So, my lord, in the display board, from my lord,
Is not here.
not
Matter pertains to challenge of respondent 9 made by the petitioner for appointment on compassionate ground. So according to the petitioner, the respondent 9 was appointed while he was a minor, saying the contrary to the position of law. Said appointment could not be should not be sustained. Stop. The petitioner had also applied for, but his case was overlooked arbitrarily. And instead, respondent 9 was appointed. Though the pleadings are complete, counsel for the respondent 9 is not present. Is constrained to refer the matter. They said after 1 week. Registry will reflect the names of all counsel in the course list.
date may be.
August.
This matter, we have sent the affidavit for getting will file it in the next week.
Mr. A.R. Tobindar, counsel for the respondent, submits that the affidavit will be filed
Next week.
by within 1 week. He therefore submits that the matter be referred. Counsel for the petitioner does not release this matter again after 3 weeks, enabling the counsel for the petitioner to file rejoinder affidavit, any such affidavit that may be filed by the witness.
Apply.
Apply.
Lordship, can you pass over the matter for handling, Lordship?
What?
Lordship, in this matter, the order which they have challenged has been cancelled and a new order has been, my lord, been taken out. I would like to bring that on addition, on affidavit.
Bring it.
I'll bring it.
It will be brought on record.
Because otherwise,
Mr. A. Fukan, counsel for the
there are elementary education.
elementary education submits that the order which was challenged in the writ petition,
Yes, sir. Page 77.
order challenged in the assailed in the writ petition. 77.
Page 77.
This is challenged.
Yes, ma'am, because this particular order was challenged, and if your lordship sees the last order, why this particular order was passed, we were asked to explain. So we have basically cancelled that and we have passed a new order. Your lordship sees the last order. Okay.
The new order
76 is the
19/11/2024 has been cancelled and a fresh order has been
passed.
Why the order dated?
My lord, 20th June 2026.
Then is there any other provision prayer in the writ petition?
This speaking order, we have already filed an additional affidavit, lordship, bringing this order in the record. Additional.
But you are challenging the order of 1911.
Lordship,
You are challenging the writ petition.
first speaking order and the last speaking order, lordship, both were copy paste, lordship. And as per
Whatever it may be, come to page 24, your challenge in the prayer is 19/11/24.
lordship,
That order has been recalled. So either you withdraw it, file afresh, or you make amendments.
no, lordship, that order has been recalled as per the direction of this honorable court, lordship.
Where is that?
Lordship, may kindly place order dated 9/3/2026, lordship. Lordship, order dated 9/3/2026.
My lord, I am sorry.
Yes.
I'm sorry.
Why?
And my learned friend was continuing.
So why should you
I'm
be
allowed
sorry?
to argue this lawsuit.
19/11/24 was withdrawn. Is withdrawn.
Yes, lordship. Kindly see their first order, lordship. Initially, my service was
Come to
provincial.
page 24.
Yes, lordship. Service provincial.
24.
At
Page 24.
page 24, lordship.
This is your prayer.
Yes.
In your prayer, you are seeking quashment and setting aside of the order
Yes.
dated 1911.
Prior to that, lordship, the earlier order of honorable court. Yes, yes, lordship.
Yes.
Yes.
Now that order has been withdrawn.
Oh, done, lordship.
Now what other prayers do you have in the writ petition?
Other prayer, lordship, what is the whole order is there, lordship? Because of my name did not appear in the dice call. My service was provincialized in terms of
We are
provisions
not
of
on that,
2017
Mr.
Act.
Counsel. You are challenging an
Yes,
order
ma'am.
issued by the department.
Yes,
That order has been recalled.
to recall.
Now a fresh order has been issued.
Fresh advisor on the same ground loss against it.
So if you want to challenge it, you either file a fresh petition or you make amendments.
And last I filed additional affidavit.
That is not enough. Your primary prayer in the writ petition is 19/11/24.
19.
That has been withdrawn.
But I filed additional that
Additional affidavit will not be
give the
will not
pendants.
be sufficient to give you grounds to challenge it. Your entire challenge is to that order.
Entire challenge that has been put down because on the same
What
ground.
stops you from making an amendment?
Amendment losses. Again,
Is there a bar?
No bar loss.
Is there an interim order?
Losses. There is no interim order.
Then why are you cutting it short by filing an additional affidavit? Follow the procedure, file an amended petition or file a fresh writ petition. Whatever suits you.
Amendment petition losses.
You think about it.
I filed the additional affidavit person.
All right.
Losses.
Then we're dismissing it.
Now, amendment may be allowed.
You have to make a prayer first.
Losses. I'm paying losses.
Mr. F.U. Borbuya, learned counsel to the petitioner, submits that in view of the submission of the respondent counsel that the order dated 19/11/24 has been withdrawn and a fresh order has been passed. What is that order?
Lordship, order dated 20th June 2026.
Page,
The additional affidavit also, Lordship.
page number.
Page, Lordship. Page 88, Lordship.
18.
Page 88, 96 is the original copy, type copy is 88, Lordship. Additional affidavit. My lord.
88.
There, what is?
By the order dated 20 June 2026. The said order has already been brought on record by way of an additional affidavit. However, considering the primary challenge in the writ petition being directed against the order dated 19/11/2024 and which order has been withdrawn, recall by the respondent that no additional or further prayers are made in the petition. Counsel to the petitioner prays for and is granted 3 weeks. Time to file necessary amendment. 2 weeks to file, to take steps for filing necessary amendment petition. Released after 2 weeks.
Yeah.
Mr. A. Fugan for the respondent.
Any day.
You have to file it within 2 weeks.
41. So in this case, we have received instruction of it. So take 10 days time to file everything.
The date may be fixed, man. Because case is non-payment of salary. He hasn't been received salary since 2006, man. Earlier he was received, my love, since he's joined, my love. But after that,
You have not paid for interest.
I did not make it. Then I would like to amend.
MSK baby appears for the writ petitioner. Mr. P.P. Sharma appears for elementary,
And the secondary.
secondary education. Submits the instructions are complete, like to file an affidavit. The
Yeah,
matter
sure.
he prays for
10 days time.
10 days time. Release this matter again after 10 days.
My lord, August 20. Of
21st,
21st. Earlier.
based on 21st of it.
Where page was it? Regarding some students and whatever by my documents. Page number 26. Number 26, my lord, he cannot claim the seniority in the existing staff of senior assistant under the district elementary education. At this line, my lord, I am blocked.
Your
Promotion is blocked.
promotion is blocked.
Due to this line. Initially, I was in the education department. Therefore, I was transferred to my PCDC.
You are transferred to
PCDC means also
The Primary Teachers Training Center,
Training
ACRT,
center.
under ACRT.
the SCRT.
what is ACR?
SCRT.
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 SCRT. Therefore, again, I come back to my department. When I come back, my lord, this order comes. Case number 26.
And at his request, he
No, my lord, this is
returned
my lord repetition.
So then
Lordship,
the
kindly-
TADA is not admissible. Page number 26.
Lordship, it is here at his own request.
Then
At his request.
TADA is not admissible.
That is my lord, that is my lord.
At his own request.
Therefore, my lord, I filed this case. It's not a my request, not a repetition. My own department.
You file your application. Why are you not filing it?
This is
We
the
will file our.
Huh?
Instruction is awaited, we will file our.
What instructions? At his own request, you file it.
That's why, Lordship. This, at his
According
own
to that,
request,
my
he
lord,
can.
this is my own request. According to this, my lord, this is a repetition. My department.
Repatriation.
Lordship.
Repatriation to which department?
My original department.
What is your original department?
Education department.
Education department.
Elementary education. It is back.
Where is the original order of transfer to SCRT?
File it page number 20. Original is page number 21. Number 21. In terms of public service. Was transferred to the primary teacher training center. After when I came to know that this center is under SCRT, then I made an application to come back.
You made an application to come back. So at his request, he was.
Originally, it was under director of elementary. Subsequently,
So, but if he comes at his own, if he seeks a transfer at his own request,
The existing seniority is not entitled.
where will his seniority be counted?
The department where he comes back, Lordship.
He belongs to the cadre of education.
Here he cannot claim the seniority in the existing staff of senior.
He is a,
The existing senior is.
he is an LDA
Lordship.
in the office of DIC,
Lordship.
DIS, Deputy Inspector of Schools, originally. Then he was transferred to SCRT.
This is
Now in SCRT, how will his seniority be counted? You have transferred him?
Lordship.
You don't know.
He was transferred to original post of LDA.
Page number 20.
Lordship, page number 20, it is written in the interest of following are transferred in the same pay scale and post. He was transferred in the same pay scale and same post.
Same post.
Lordship.
So how is his seniority to be counted? In regard to which cadre, which post? LDA. In the education department.
Lordship.
Now from there he wants to come back
He wants
by
to
way
come
of
back.
page 26.
Lordship.
Why his seniority is not counted?
Lordship, let me file affidavit in detail.
Mr. D. Gugoi for the petitioner, and Mr. P. R. Sharma for the elementary education. Mr. Sharma removes his prayer for the time to file affidavit. Complete his instructions and file affidavit. Grievance of the petitioner is that by order dated 11th January 2019, petitioner was transferred in the same grade and scale of pay and posted in the office of Deputy Inspector of Schools, Dibrugarh, from his earlier posting and the pre-primary teacher training center, which is under the SCRT. Stop. However, the said order also provides that the petitioner cannot claim seniority in the existing staff of senior assistant under the district elementary education officer, Dibrugarh. Therefore, the petitioner is aggrieved by the fact that essentially by the order dated 11th of January 2019, he is repatriated back to his original cadre, but is not allowed, but his seniority is not allowed to be counted. So, being agreed, the present file. The state has not filed affidavit. Mr. Sharma will endeavor to complete instructions and file affidavit and explain as to why the seniority of the petitioner has not been permitted to be counted. The order dated 11th January 2019, released after 3 weeks.
possible.
21st of August.
Highly obliged.
The respondents have filed their affidavit and we have filed our reply today in the morning. And it's advanced copy of the PDF has been sent to the council, Mr. U Sharma. So the matter is can be taken up on 10th.
Taken up on
10th of August, Your Lordship.
why 10?
Lordship, there is urgency, Your Lordship.
What is the urgency?
The petitioners are deprived of their appointment, Your Lordship. They have been they have been called for verification, and after that, they were called. They were rejected, Your Lordship, by publishing a final cut-off list.
It is submitted by the council for the petitioner that the reply rejoinder affidavit has been filed today. However, saying it's not connected to the case record, and it's free to trace out the affidavits stated to be filed with the parties and connect it to the case record. Matter be listed for, this is for admission.
Yes, Your Lordship.
10th is not possible.
Then, Lordship, that 13th, Your Lordship.
All right, 10th.
Obliged, Your Lordship.
This subject of this liquidation order of penalty in a disciplinary proceeding. So the affidavits have been exchanged. The affidavit, my lord, none of the questions raised in the liquidation have been answered. Your worship was pleased to call for the reports. And my lord, what I pray for today is that my lord, your worship will forgive the reports.
Chief records received, Your Lordship.
Why do you want to go to the records?
Because
Before
my
you
lord,
open your-
there are certain things I said, for instance, my lord, that the appointment of inquiry officer, appointment of presenting officer, that was not communicated to me. Because issue before. Then, my lord, I was also not communicated with any document saying that if you want a defense assistant, that was also not there.
We'll examine it, and if we find that it is necessary, then we'll permit you.
My lord, my prayer is that, my lord, your worship is at least, my lord, glance through the, my lord, report.
First, let us go through the records and see what is there.
That can also be done, my
It may
lord,
not require your perusal of the records. Or if we find that yes, the documents are there, then we'll certainly permit you.
but
Satisfy
your
yourself.
Your worship,
Yes. The records are here.
Yes, sir.
Where is the show cause?
the show cause notice, your worship will find at page 27.
27.
Chief, his records, Your Lordship, received sometime, Your Lordship. I have not received the earlier, Your Lordship. Today itself, Your Lordship, I have received this records, Your Lordship. And this is a bulk one, Your Lordship. I needed to flag mark the relevant portion also. So, Your Lordship, some other day, maybe Your Lordship post this matter. Your Lordship, by that time, Your Lordship, I may be able to, Your Lordship, flag mark the necessary parts, Your Lordship. Attendance sheet is also there for hearing that 6/8/2024, which has conducted, Your Lordship. Some show cause notice is also.
Senior counsel, petitioner, Das state. Ms. Das submitted the records and receipt. However, she would like to receive today.
Today itself.
Therefore, she would like some time to apprise herself with the reports in order to assist the board. Each time. Since the pleadings are complete, the records are received, it will be listed after 1 week.
I renew my prayer. May I renew my prayer?
On the next day, if required. Otherwise, if the state council is comfortable permitting you to see, we no. Court can't have.
Unless your lordship might not see.
No, we can't direct you. We can't direct them. How can we direct them to produce the records? Go through. If you wanted any information, there are procedure by which you make an application. In the course of the hearing, we find that yes, certain facts.
Important fact I'd like to just point out, my lord, two persons were, my lord, their witnesses were, they were examined through video conferencing. And that has not been reflected in the inquiry officer's report. So whether that is there in the, my lord, the record or not, that is the most important part I wanted to see. Anyway, my lord, your lordship will consider it on the. Fix a date, my lord. For your lordship.
6th of August. Sir.
Letter to 6/8 of 20. I'm deeply opposed.
This matter, I'll take some accommodation. I'm engaging my senior Mr. H.K. Dasman. Business wants to engage senior consultant.
Mr. D. Wood submits that the petitioners against the senior counsel, Mr. H.K. Das. Mr. Das, pays for accommodation. And 6 liberty to have the matter listed after 1 week.
See some difficulty.
Mr. S.K. Medi, 13 appears for the union.
He apprised me when he has some difficulty.
13 of August,
Is agreed to by both parties on 13.
For the matter, my lord, I have neither been terminated nor suspended, but my lord, not allowed to continue in my service. My lord, I had been, my lord, implicated in a case, my lord, and wherein I was arrested also for charging bribe. My capacity and my lord, after the my lord, my arrest and my lord, behind the bar, my lord. From then, I have not been allowed to work. Accordingly, my lord, when I approached before the Honorable Court, my lord, by challenging that I have not been placed under suspension, not terminated, so I should be allowed to continue when I came out from bail. But now they have said that some proceeding had been initiated, and as I am an contractual employee, my contract had not been extended. So therefore, I do not have any rights. That is their stand, my lord, the affidavit. But first of all, my lord, I beg to draw my lordship's attention, my lord, to my initial appointment, my lord. My lord, may kindly turn page, my lord, annexure 134 page. My lord, Mr. Azharul Islam is hereby engaged as a district program officer, AS SSA Karimganj, as per the selection by the state level selection committee SSA Assam in the interview held on 23/9/2008 for the position under Assam Sarva Shiksha Abhijan Mission. He is asked to report at the district mission office SSA Karimganj for executing the deed of agreement for engagement on contract basis initially for 11 months, latest by 22/9/2009. In case he fails to report, the district mission office Karimganj, it will be presumed that he is not interested in the offer of engagement and the offer of engagement will automatically stand cancelled. Accordingly, my lord, I did approach and an agreement as page 35, annexure 2 had been executed, my lord, on the 17th day of September 2009. So, my lord, and this type of agreements has been, my lord, continued time to time. And in the meantime, my lord, on 26/7/2011, my lord, I took a mutual transfer from, my lord, the office at considering their own. My lord, may kindly turn to page 37, my lord, lecture 3 is my mutual transfer order, my lord, considering their own prior petition and for the smooth implementation of SSA activities, the following district program officer Assam is hereby transferred and posted in the same capacity as follows. So from Morigaon, and I am from Karimganj to Morigaon, my lord, had been posted. And accordingly, my lord, a new deed of agreement had also been executed at page 38, annexure 4, time to time, my lord, that because, my lord, 11 months continuation. From lord, is that page 38, annexure 4 is the next agreement with same terms and conditions, my lord. At page 40, annexure 5 is an important order, my lord, of 15/6/2012. In pursuance of the approval of the mission director SSA Assam and considering upon their own request on personal ground, MD Lutfur Rahman, District Program Officer Assam, SSA Gwalpara, is hereby transferred and posted in SSA Morigaon in the same capacity Vice MD Azharul Islam, District Program Officer AS Morigaon. Accordingly, MD Azharul Islam, District Program Officer Morigaon, is hereby transferred and posted in SSA Gwalpara in the same capacity in place of MD Lutfur Rahman. So, my lord, I had been transferred time to time. My lord, this notification at page 41 is also important, my lord. In pursuance to the approval of the Executive Committee Assam, it is to notify that the of agreement of all employees under the contract in SSA Assam against the post sanction under Soins of Assam will be of 5 years. Instead of the prevailing period of eligible will be provision, annual performance appraisal of the every employee, both under the contract and deputation attachment to be conducted by his, her controlling officer and should subsequently forwarded this appraisal to the mission director for final approval as per the provision of so and so. The employees have to enter a fresh modified deed of agreement with SSA Assam with a specific job assessment. So, from this notification, it is clear that 11 months had been, my lord, converted into 5 years term, my lord. So, my lord, this is an order at page 44, my lord. I am relying. Let me kindly turn page 44, annexure 7. This is an order issued by the mission director themselves, my lord, that save as otherwise expressly provide in service regulation and financial regulation 2003 of Assam Sarva Shiksha Abhiyan Mission Assam. It is hereby notified that the spirit of the rules and procedure as prescribed under the Assam Services Discipline and Appeal Rules 1964 followed by the government of Assam for the inquiry, departmental proceeding, award of punishment, appeals, etc. shall be followed by the Assam Sarva Shiksha Abhiyan Mission as and when any inquiry or departmental proceedings are required to be conducted in respect of any employee, contractual or otherwise, employed under the so and so. The order shall come into force with immediate effect. So, my lord, as there is a, my lord, no specific service rule has been, my lord, enacted under 309, my lord, for the purpose of this type of contractual employees. So, these orders governs that what procedure and the mode they are going to follow while conducting the departmental proceeding for these categories of employees. Now, accordingly, my lord, in page 47, annexure 8, then another order, my lord, by which I had again been transferred, my lord, from Gwalpara to Dhubri. In the interest of public service and its functioning as the designation of the.
Hey, what are you challenging here?
My lord, I am challenging, my lord, basically for not allowing me to continue in my job, my lord. Because of, my lord, what has happened, that's why, my lord, I am referring to the annexures, my lord. There is a case while I was working, my lord, may kindly turn to page number.
So, what happens to your prayer A, page number 30?
Yes, my lord, the prayer A is
That is a proceeding. No, my lord. This prayer has not yet been culminated any finality, my lord. They are proceeding, my lord. It has not yet been culminated to
Are you still pressing this?
my lord, because it has not been yes, my lord, because the proceeding initiated against the petitioner had so cause notice dated so and so, my lord. Now this proceeding, my lord, they have not yet been finalized as per my instruction and my lord, the knowledge which I have been furnished with. If my lord may be pleased to find the FIR which they have lodged.
Now,
My lord.
pursuant to this, you have not been allowed to work.
No, not been allowed to work.
No termination order.
No termination, no suspension, and they are saying that as my contract has not been, my lord, extended, so therefore it should be presumed that I have been removed from my service and job, my lord. That is the
Where is the clause in the contract again?
No, my lord, the clause in the contract again, after this, my lord, 5 years tenure term, they have not issued any such type of, my lord, contract deed, but my lord, till the date of my arrest and suspension, my lord, till the date of my arrest, my lord, I had been paid my regular salary, my lord. So therefore, my lord, it can be presumed that the authorities has not yet, my lord, terminated or released me from my contractual engagement or dues.
You are referring to the contract at page 35.
My lord, because, my lord, the page 35 says, yes, my lord, this is the last contract agreement as per my knowledge, and another contract is at page, my lord.
Now, this is for a period of 11 months.
That is correct. That is correct. Now, my lord, kindly turn the notification, the 5 years contract which they have extended from 11 to 5 years, my lord. My lord, kindly turn to page 41. This is the extension of the contract to 5 years, my lord. Under the contract in SSA Assam against the post sanction under so and so Assam will be of 5 years instead of the prevailing period of will be provision of annual performance appraisal and so and so. So, my lord, after this, I have been allowed to continue in the same capacity, and I had also been transferred from one district to another district, and my designation has also been changed by an order dated 21/9/2016 at page 47, my lord. After this, though, my lord, there is no any fresh contract agreement has been executed, but I had been allowed to continue, my lord.
No, this notification is of 3/7/2012.
That is correct.
And there is an agreement on page 38.
My lord.
Where the period includes period reflects 5/12/2011 to 4/12/2016.
That is correct, my lord. This is the agreement of, my lord, for 5 years.
5 years.
5 years, my lord. This agreement will automatically lapse on so and so, on so and so.
So and
So, my lord, if we presume, my lord, that 4/12/2016, there is no any fresh contract had been executed, my lord. Now, if my lord may be pleased to find, I have, my lord, annexed another contract, my lord, at page 49, annexure 9, my lord. This is also for 5 years. This is executed on 28/9/2016, you know. This is also agreement will automatically lapse on 4/12 that on so and so, so and so. The district program mission district
4/12/2016, same date.
First party for a period of 5 years. But my lord, if we have to count from 28/9/2016.
But the agreement has a specific date on which it will lapse.
That is correct.
You have signed it.
That is correct. But my lord, it says that the first party for a period of 5 years with effect from so and so. This agreement will automatically lapse on 4/12/2016. Now, my lord, respectful submission before my lord is that, my lord, if we count from the date of executing this agreement, that is 28/9/2016, if 5 years is counted, my lord, then it will
Can be, because the agreement categorically says it will automatically lapse on so and so.
Then, my lord, it is contradictory. is there.
How?
Because my lord may kindly peruse this paragraph 1, my lord. That on and since the execution of this agreement, the second party shall act as so and so component in the state mission office, Assam district mission office under so and so, the first party for a period of 5 years with effect from so and so. So, my lord, if I have to
go before an appropriate forum to file suit for specific performance.
But that is not my case here. My case is for not renewing the contract. Not I had been allowed to continue exactly similar set of Milord procedure has been adopted state-wise for the same set of employees. What they have done, Milord, they have not executed a fresh agreement also. So, but they by the act of theirs,
See, you are a contract employee. There is a specific cutoff date in the contract. You, for some reason, you are allowed to operate beyond the cutoff date. You are working beyond 4/12/16. That is your case. There you are working beyond 4/12/16.
Correct.
But there is no contract renewed. Assuming that services were extracted, you are given your salary and everything.
Now, Milord, when I was not been arrested or not been Milord detained in the custody, till the date of my arrest, I was discharging my duty in the office on the FIR. Now, Milord, when this FIR was lodged, then when I came out from jail on bail, Milord, then when I applied before the authority that I should be allowed to continue by Milord specific representation, they have not allowed me, Milord. When they have not allowed me, then only I could learn, Milord, that there is no any decision has been taken as regards my suspension, non-renewal of the contract, or my termination. There is no any specific order they have till date had yet been issued, Milord, that terminating my contract. So therefore, Milord, from their
terminating contract will presuppose that there was an existing contract. Your contract expired on 4/12/2016. Beyond that, you had rendered your services.
That is correct, Milord.
Till the time you were arrested.
Yes.
Now, according to you, beyond 4/12/2016, that is from 5/12/2016, till the time you were arrested, it was not covered by any agreement.
But if it is not covered by any agreement, but in a government institution or in a government job,
we are trying to understand the facts. From 5/12/2016 till the time you are arrested, although you have rendered services, it is not under any agreement.
Specifically in a return from no
agreement, but you are allowed to work.
I have been allowed.
Salary is paid.
Presume to be not extended my contract. Though it is not in a written form, but by the act of the respondents, they have allowed. Now, a person who is working and is now above 55 years of age. Now I am. This is the only mode of my surviving and my family. Now, other similarly situated persons are still working and continuing in a similar mode, that without extension of their contracts also.
Did you not file any representations before the authority?
Yes, my lord, I have filed. My lord may kindly turn. My lord may please to find my representations. My lord. Starts at page, my lord. At page 74, my lord, the type copy is available at page 71. This is the reply to the so-called. Joining the page 76, Milord, annexure 16. Page 76. Huh? 70. Yes, Milord, page number 76. The mission to the district mission coordinator SSA Dhubri dated 27 September 2022. Basing on this, the authorities also acted upon to my representation at next page. The next page, my lord, after my representation, mission director, the district mission has written to the mission director, my lord, regarding joining of so and so subject. I have the honor to state that Sri Azharul Islam of this office was earlier arrested by the Vigilance and Anti-Corruption Department, Assam, in connection with so and so, as amended in so and so, which was informed from this end by this office letter under reference. Recently, Sri Azharul Islam got bail from the Honorable Court of the Special Judge Assam, white order dated so and so. Now, Sri Azharul Islam submitted an one prayer petition copy enclosed and approached the undersigned to allow him to resume his duties as a secretary. Under the circumstances, I would like to send his prayer petition seeking necessary direction from your kind hand in this regard. The enclosed prayer petition and supporting papers may kindly be seen, which are self-explanatory.
What happened after that?
That, my lord, an hearing had been conducted on 6/10/2022. My lord, may kindly turn to page 78, my lord. Notice has been issued to me. Your letter dated with reference, you are requested to attend a hearing at 11 a.m. in the State Mission Assam in connection with arrest. This is for your information and necessary action. This was issued on 6/10/2022. So, responding to this, I did not approach in the hearing conducted, and that hearing, till date, I have not been furnished any concluding report or any kind of decision after the hearing. Then again, I have filed a representation at page 79, annexure 19, with the similar prayer that I should be allowed to join. So, several representation has been filed. On the last representation I have made is at page 84. Last representation, and that has been also received by 16/2/2023. When this representation did not serve or my prayer had been exceeded, then only I have approached before my lordships with these prayers. One thing is noticeable.
What happened in the hearing?
Hearing, after the hearing, they have not done anything,
No order passed.
No, so-cause notice had also been, issued to me, and I have also responded to the so-cause notice also. May I kindly have a look, This so-called notice reply I have given is at page 71,
What have they stated in their affidavit?
The affidavit, several affidavit has been filed, three affidavit. But regarding these conclusions of the hearing, they have not, I have not found any, regarding this. The crux of their affidavit, is that as my, contract has not been, extended. So therefore, I am no more an employee. That is their standing. I cannot claim as a matter of right to allow me to continue in my post. But my lord, may I have found that, one letter they have also written, and once they have conducted a hearing, at least reasonable conclusion they should arrive. And in the criminal case, I am also facing the trial. It is in the evidence stage, and I am fully participating. If it has been acquitted, if I got the acquittal in this proceeding, then the whole scenario will be changed.
Yes, Mr. Nayak. What was the outcome of the hearing?
Lordship, so far as my stand is concerned in the affidavit, Lordship, the petitioner did not appear before the executive director on the day of hearing, that is on 24/3/2023.
Did not appear.
He did not appear. It is the stand, Lordship. It has not been disputed. 114.
You did not appear.
No, I have appeared. Because
One
on
on four,
the day of appearance, nothing, only just few queries has been put in, and that is
There is a categorical averment that you did not appear.
No, they have made the averment, but my instruction is that I did appear. I did appear, and I also participated.
You
Even,
disputed this in your rejoinder or anything?
I have filed my rejoinder. Additional.
Lordship comes to page 114, Lordship, of my additional affidavit. The first paragraph here, Lordship. After according the prosecution sanction, when the inquiry report was again placed before the disciplinary authority, the said authority, after having considered the report, directed the executive director to call the petitioner in person and take personal hearing on the findings of the report of the inquiry officer. Accordingly, the petitioner was asked to appear before the executive director in person on 24/3/2023 at 12 noon in the state mission office, SSA Assam at Kahalipara, Gauhati 19. But as per available materials on record, the petitioner did not appear before the executive director on the day of hearing, that is on 24/3/2023. Doctor, may kindly see the notice at page 125.
Where is your averment, Mr. Bhuyan, that this is a false, this is not correct?
Well, actually, many affidavits.
How was this appointment made? By way of some selection?
Yes, my lord, advertisement and selection, my lord.
Lordship has already seen the,
1 minute.
the contract at page 38, Lordship. Clearly, it was up to 4/12/2016, Lordship. Then if Lordship comes to.
But he was allowed to work beyond that.
Yes, I'm coming to that, Lordship. Page 67. Page 67, Lordship, it is the so-cause notice, Lordship. If Lordship comes to the last paragraph. Further, the monthly salary of Jarhul Islam District Mission Officer should be stopped. So, Lordship, even if it is assumed that by giving him, it was an implied Lordship extension of the contract, that has been stopped if the moment this order was issued on 16/9/2022, while stopping his salary, Lordship.
Why was that done?
So because of the so-cause notice, Lordship, he was arrested, inquiry was initiated.
Was is to find out whether he's guilty of the allegation.
Lordship, that
By stopping his salary, not allowing him
Lordship,
to work, you have concluded that he's
probably,
guilty.
yes, the probability, the exact reason will be there, have been noted in the note sheet, Lordship. This is the order, Lordship. From this date, his salary has been stopped. So he cannot take that plea that, Lordship, as I have just paid salary, so my contract has been extended. Yes, Lordship, that is the implication. If you were being paid your salary, Lordship, your contract has been extended. But the moment it has been stopped, Lordship, that, everyone would not hold.
Yes, what do you say regarding the hearing part? You know,
My lord, in paragraph 18 of my writ petition, my lord, I have specifically said that the petitioner appeared for hearing on the scheduled date and time and placed his
is
case
denied.
on
That
his
is
defense.
pursuant to the notice dated 22, Lordship. If Lordship, in the writ petition, there is a notice for appearing before the hearing authority, Lordship. That notice was of, if that is there in the writ petition, Lordship. page 78. It was of 2022, Lordship. And last notice was in the year 2023. Therein, Lordship, he stopped appearing.
No, no, my lord, I have made the last representation on, my lord, 16/2/2023. My lord, this has been received by the authority, my lord. This is my representation. My lord, had there been any notice they have issued to me, whether it has been furnished in a proper form or not, that has also not been, my lord, discussed. Now, my lord, regarding this participation of myself in the hearing, my lord, I am always ready to participate in the hearing, my lord. There is no, because I as
What orders were passed?
my lord. If I do not appear, they can pass a transfer.
Order is not there, Lordship, as it
Okay.
appears from
My-
my additional affidavit, Lordship. If Lordship comes to page 121 of the affidavit.
There should have been an order that he did not appear, so.
Yes, Lordship, an attempt has been made. Why the order was not passed, Lordship, to explain that, Lordship. Even assuming, last paragraph, Lordship, in page 121. Prior to that, Lordship. Furthermore, the answering report most humbly begs to say that on examination of service record of the petitioner forwarded by the ADC Education and DMC SSA Dhubri.
That you have already shown.
Yes, he expired on so and so. Therefore, his service contract was never renewed. That is there. Even assuming that his service contract agreement deemed to have been extended, as he was allowed to draw salary remuneration. Even in that situation, such deemed extension of contract cannot be treated as still subsisting, as the competent authority in SSA has taken a decision to stop his monthly salary from 16/9/2022 by letter number so and so dated 16/9/2022. Therefore, in view of the above explained facts and circumstances, it is the view of the SSA authority that once the contractual service of the petitioner ceases to exist, there is no requirement for the authority to take a decision as to what penalty is to be imposed against the petitioner pursuant to the proceeding initiated against him. In this regard, it is also to be taken note of the fact that after submission of the inquiry report, the petitioner was granted an opportunity to represent his side, which opportunity the petitioner preferred not to utilize. Accordingly, it is humbly submitted that there is no other conclusion which can be drawn other than the conclusion that the status of the proceeding initiated against the petitioner by issuing the so-called notice dated so and so is complete.
So what kind of a conclusion is this? The
Lordship will-
department must
Lordship will
conclude it by
appreciate-
passing
Lordship will
a
ap- yes.
specific order.
Yes, Lordship will appreciate, Lordship, even if an
Even
order
if
is
you're,
passed.
even if you're dropping the proceeding
No, that is-
for the petitioner not appearing,
Yes.
then also you
Yes,
have
I
issued a show
understood, I
cause.
understood, Lordship. But once he is not there in the service, Lordship.
Huh.
So what is the, usefulness of an order?
Then he's not there in the service.
Neither I have the, after he
He's
has,
not there in the service by virtue of your show cause. You have issued the show cause
the show cause has
and
two
you have
parts.
stopped
No,
the salary.
Lordship will appreciate that show cause has two parts.
Huh.
One, show cause to appear in the proceeding, and second was stopping his salary.
That's right. So
And-
if you have stopped his salary,
Yes,
can you now turn around and say he's not in service? It's
Yes.
because you have stopped his service,
because that was
stopped his salary.
because that was the only, the way to say that my service has been extended. Because I'm drawing salary.
No. There, all these, you can't jumble up everything. He is working on a contract. His contract entered in 2000, completed in 2016.
Yes.
Beyond that, you allowed him to work. He
Yes.
was working, he was paid his salary
Yes,
until he was arrested in some case and then you issued a show cause. Now in the show cause, once you have issued, it was issued on 16/9/2022. So till then he was on service, although there is no contract, written contract. Now pursuant to that, you have stopped his salary on 16/9, same day.
yes.
And then you say that he is no longer in service, therefore it doesn't make any sense to
Yes,
issue
because,
notice.
because his salary has been stopped.
So you have stopped it.
Yes.
Uh,
So that is the decision. Lordship, what should have
How
been?
can it be their decision?
Lordship, what is the assumption, Lordship?
Then
Just
what is the point in issuing the show cause? For what purpose have you issued the show
Lordship,
cause?
that is what we have realized, Lordship. That is the explanation, Lordship.
That can't be an
Because as
explanation.
you are not there in the service, Lordship, what is the use of issuing a penalty
You can't
order?
improve an order on explanation. Can you improve an order on explanation? Subsequent explanation.
Yes,
You
that
can't
is,
do that.
one, Lordship. And in the meantime, Lordship, if you file this petition, that is also one of the reasons not passing any turnout. Probably it is already subject. 2020.
You give him, you continue the hearing, pass an order within a fixed period of time. Examine his grievances, pass an order.
From the stage, Lordship, when it left. From the stage, Lordship, on last, yes, that can be done. We only need to pass an order.
No, it's not about you passing an order. You have to give him an opportunity of being heard.
By giving an opportunity.
Yes. Yes, Mr. Bhuya.
Well, I have already bring a
The
notice.
purpose of giving liberty to the state or a direction to the state to continue hearing is not to facilitate passing an order. It must be a hearing in an effective sense.
But my submission will remain, Lordship. Even after completion of the inquiry, Lordship, opportunity was given to him to appear.
But then you are now trying to clarify that that opportunity carries no meaning because he was already out in
in
service.
that situation, what your Lordship is proposing, in that situation, will it be necessary for me to give him another opportunity of hearing?
Then you must pass an order to that effect.
Lordship may direct to that effect.
No,
Lordship.
why should we direct you to pass an order? It was incumbent on the department to pass an order.
Yes,
So,
otherwise,
so
inquiry
that
report has
order,
already been
that
submitted.
order not having been passed, the proceedings are still open.
That can be done, Lordship, provided Lordship will clarify that as he has already been given the opportunity and he decided not to avail that opportunity.
Not fault, their fault. Now
Not my fault, Lordship. He has no averments in response to my.
And secondly, if how do you allow a person to work without any contract when the very source of employment is through contract?
That is, Lordship, he is not the only person, Lordship. That's it. Generally, it is not that on the very next day, I have to extend the contract. Or it is also not a situation that it is mandatory for the authority.
It's not a question of next day. The contract expired in 2016.
Yes.
So was issued in 2022. That is 4 years.
So my Lordship will take note of the.
Had it not been for the show cause notice, he would have completed service for 5 years or more.
No, Lordship, that decision is there. His service was extended only because of the fact that the implied extension was there only because of the fact that he was receiving salary. Once the salary is stopped, Lordship, that implication, that impliedness has also gone, Lordship. So, Lordship, what I am trying to emphasize, Lordship, may kindly see page 127. Page 127. So, this is the notice issued to him, Lordship, to appear on 24/3/2023. Against this, he has no submission, no response, Lordship. In connection with this letter, I have.
Then we'll have to see. Then we'll have to examine your records, how you served the notice, how the notice was served on him, because he was not in the office.
Lordship, he is not disputing.
No,
he is not disputing.
He is disputing it.
Not disputing. Where is the averment,
No, I have made the averment that respond.
Let him show, Lordship. Let him show. Where is the
Responding
averment?
to this notice, I have participated.
So this is the
hearing.
notice, Lordship, I am showing. At the same time, I will also making statement, Lordship, that he was given the opportunity. And he preferred not to avail. So that is why I am submitting, Lordship. Once opportunity has been given and he prefers not to avail that opportunity, Lordship may direct me to complete the, proceeding that was initiated. And
direction
pass the necessary order.
It is within their discretion, Milord. They can proceed with
After hearing the petition,
Mile.
you have to give him an opportunity to
Yes,
be heard.
That is what I am trying to. Lordship, that opportunity has been given.
No, if
That opportunity has been given, but you did not complete the proceedings. You should have completed the proceedings. Now the proceedings being open, petitioner being before the court, no prejudice will be suffered by the respondent by giving an opportunity of being heard and then passing a final order in the proceedings if you want.
That have been a situation, Lordship, once it is there in the pleading, disputing the notice, disputing my averments. That is not there. Yes, the final order was not passed. To that extent, Lordship, I admit. Enquiry was complete. Final order was not only passed. And it was also because of the fact that there already adjudication of this petition was going on. That is one reason. And second reason, he was no more in service, Lordship. But to that liberty, Lordship, once again giving in an opportunity. Of course, it will be decided by your Lordship, but still, Lordship,
So you have decided to issue a show cause.
Yes.
There was no contract.
No.
He rendered services. There was no
Lordship,
contract.
at
You did not seek to terminate him. You decided to issue him a show cause. And the proceedings were initiated. He appeared in 1 or 2 hearings and thereafter did not, then his salary
Moreover,
was
Lordship,
stopped.
in similar situations, Lordship, recently our division bench passed one order. Lordship. So termination and release from services are two different concepts. Here in Lordship, it's not a case of termination. Because of his expiry of the contract, Lordship, his contract was not renewed. That is the only case, Lordship.
He's not even praying for that. Are you praying for a renewal of a contract?
Yes.
No, my lord, I should be allowed,
is the prayer.
my prayer is to, my lord, that I
Allow
should
me
be
to
allowed
join my
continue. My lord,
service means I
only the
retain my
reason
contract.
for not allowing me, my lord, to continue is a criminal case. Otherwise, my lord,
See,
till date.
if it is in a, if the given facts were like that, that after conclusion of his contract, it was not renewed. And he has come before the court asking for renewal of the contract, it falls in a different compartment. Here, by implication, he was allowed to continue. Meaning there was some contract existed between the employer and the employee,
Yes.
although not in writing.
The only reason for such implication is that he was given salary.
Given
That
salary,
was the only reason.
given salary by whom?
But the state by the authority.
That's right.
But the moment it is stopped,
No,
Lordship, thereafter,
Mr. Counsel, are you contemplating to suggest that salary was given but he did not perform his work? He was only receiving salary, no work. Is that the case? No. He was given salary in response to the work executed. And the employer is expected to know that the employee is in service paying, earning a salary. So there was no written contract, but by implication, his contract was extended until the show cause notice was issued.
yes, Lord, that is what I am submitting. Exactly, that is my submission. It was deemed to have been extended
So
because
once,
we are
so
paying
if
him
you
salary.
extend it, it has to be for, as per your papers, it must be for a period of 5 years.
Not for 5 years.
It's for 5 years
Only-
subsequently.
It was just, the contract was not signed because there was no decision in the files, Lordship. The moment decision is taken to extend this contract, there will be a contract. That contract is not there because no decision is not there. to
By
extend.
implication, it is there, you are paying him
That is,
salary.
yes, Lord. It was temporary basis. Implication, it was on temporary basis. Why that implication, Lordship? Just because we were paying him salary. The moment it is stopped, Lordship, that implication has also gone.
No, that stoppage has come pursuant to issuance of show cause notice. If that stoppage would have come, that your contract has ended, we are stopping your salary. That's it on a different compartment.
At one, Lordship,
Because your contract is very clear,
Yes.
automatically expires on so and so day.
on 6.
So it is clear to both parties that from such and such date, he is no longer required to refer his services. But employer pays him a salary, he continues to work. By implication, the contract is extended. There is no written contract. It goes on until there is a show cause notice.
Yes,
And
Lordship.
on the same day, there is a direction to stop
Yes.
his contract.
Extended month-to-month basis.
That also,
Yes, it was not extended for 5 years or 1 year.
whatever.
It was
month-to-month,
month-to-month basis.
All right, month-to-month basis.
So till the moment his salary was, he was receiving salary, it was extended. Can there have any such, implication after the decision?
Nothing, because you issued the stoppage of salary pursuant to or simultaneously with the show cause notice.
It may not be said that it was because of the so cause notice.
We
Probably
don't
there
know.
is a different.
We don't know. It was because
It-
both are dated together.
Probably there is a decision also not to extend his contract.
I do not know.
So at this stage, Lordship, what I am submitting, yes, pursuant to an proceeding, Lordship, an order was not passed. It should have been passed, but it is the thinking of the authority.
No,
that
but
just
you can't
because
pass
he is
an
not
you
there.
can't pass an order in a matter where the authority proposed to pass an order about 5 years back without giving him an opportunity. You're passing an order, you are contemplating to pass an order.
Yes.
So, under all, with all humility, you should give him an opportunity to be heard. Because you've issued the show cause, you're passing an order in the show cause notice.
Lordship,
In the
that
proceedings
opportunity was
initiated in
given
the
to
show
him.
cause notice.
Lordship, it has in fact been given to him.
Have you submitted your reply?
Yes.
He submitted his reply also.
No, so far as that last notice, Lordship.
No, so cause reply I have,
Show cause-
notice is not there, notice is for hearing, not for
Page
reply.
127.
My
No,
lord,
so
kindly,
cause reply has he
so
filed or not?
reply I have
That,
filed.
that show cause, Lordship, initial show cause notice is there at the petition, Lordship.
16:9.
1610.
Huh?
1610, Lordship. The so cause notice 16:9. Then therein, Lordship, at page 78 was,
So
it
in
was, he was
the, in
directed
the
to
show
appeal.
cause notice, he was permitted to file a reply.
Yes,
He has filed a reply at page 71.
yes, it appears he has filed his reply at 71. Then Lordship may kindly see page 78, this was hearing. And if Lordship comes to my averments in the affidavit, Lordship, it was complete. Enquiry report was also submitted.
Hmm?
Even the enquiry report was also there.
Where?
Lordship may come to enquiry report has been submitted, Lordship.
I have not received any inquiry report.
That for that only, Lordship, that opportunity was given.
My lord,
Where is the government that inquiry report?
Yes, it is.
Inquiry is complete.
Page 122, Lordship. Second paragraph, Lordship, in the middle portion, Lordship, in this regard. 122, second paragraph in the middle portion, Lordship, in this regard. It is also to be taken note of the fact that after submission of the inquiry report, the petitioner was granted an opportunity to represent his side, which opportunity the petitioner preferred not to utilize.
I have received any inquiry report.
That is, you are saying, your client is not saying.
No, my lord,
Inquiry report submitted.
submitted, but copy has not been furnished. to
Where
me.
have you stated that in your, where have you raised this issue? After the
My
affidavit?
lord, my lord. Because, my lord, during the course of the inquiry, had it been a case, my lord, regarding the Assam Service discipline and appeal rules, they.
Have you received the copy of the
No,
inquiry
no,
or
my lord,
not?
I have not
Where have you
received it.
stated that?
My lord. I think that.
This is an averment made in the affidavit.
Madam, may kindly turn to page number 230, my lord.
230.
230 of my. My lord, I'm reading from sub-para, my lord. Apart, my lord has got it, my lord.
Yes.
230. Apart from that, the deponent denies the averment of the respondent number 3 that he was never called for hearing on so and so, and begs to submit that even if he was called, but he did not receive any intimation letter about that, the deponent has never been made to know about the findings of the inquiry of the disciplinary proceeding initiated against him, and no any formal order for closure report has been issued against his disciplinary proceeding.
But you don't deny these averments.
Nor the copy of the same was
Have you denied these averments?
I'm denying it.
How? There has to be a specific denial.
Nor the copy of the same was
Mr. Bhuya, you have to deny it with reference to the averments made in the affidavit.
No, this
is an independent averment that you're making without
this is-
reference to
this
the averments made in the affidavit.
contrary to the minute made of the respondent number 3 in one of the paragraph page 120 minute. This paragraph at page 120 of their additional affidavit I am replied in respect in paragraph 8 minute. The may I read over from the top paragraph 8 that the deponent further begs to submit that contrary to the averment of the respondent number 3 in one of the paragraph of their additional affidavit that the spirit of the so and so rule of the so and so is
No,
absolutely
there is no
denied.
specific denial.
My lord, is absolutely denied by the deponent, my lord, and begs to reiterate. This is the denial, my lord. It is absolutely denied by the deponent.
You
regarding-
are denying the fact.
No, no, my lord, I am denying the page 120 of respondent
Ah.
number 3, my lord. Now,
Ah.
my lord, may kindly verify at page 120 of what they have said, my lord.
Spirit of so and so has been followed is
My lord.
absolutely denied.
My lord.
But the question that I would put to myself is,
My lord.
where was the difficulty in giving a specific reply that no inquiry
No, there
report
is-
was served?
There is no difficulty. I should have, my lord, I should have, my lord, in a state.
Then
No, my lord, if my case is being not allowed also, my lord, I will not submit unfairly before my lord. Because, my lord, there should be a specific denial. That is
That's
correct,
right.
my lord. But, my
But
lord,
this denial again requires an interpretation, whether it
My
is denial to that
my lord.
or to the other
My lord.
developments made in the affidavit.
It is maybe, my lord, the pleading is not specific, my lord. That is there, but, my lord, I have said, my lord, I have, apart from that, the deponent denies the averment of the respondent number 3 that he was never called for hearing on so and so and begs to submit
Then
that.
you produce the records, let us
My
see
lord.
what has happened.
My lord.
The petitioner before this court is aggrieved by not by the inaction of the respondent and permitting him to continue in his service, contractual service as so and so. What is the post?
My lord, it is DPO, my lord, District Program Officer.
District Program Officer
within
under
bracket
the,
SC.
under the
Well, under the Sarva Shiksha Abhijan. Mission
Sarva
Assam.
Shiksha Abhijan. So, although the initial contract of the petitioner, which was extended from time to time, expired on 4/12/2016. And no written contract was executed by him between the petitioner and the respondents, It is not in dispute that the petitioner continued to render his service and salary is also paid same capacity till a show cause was issued to the petitioner on where is the show cause?
My lord, the show cause notice, my lord,
Dated
Page number
16/9/2022.
71, my lord.
This show cause was issued. The writ petitioner due to the fact that there was an allegation of receiving illegal gratification by the writ petitioner and he was arrested by the investigating authority in connection with the CBPS case number 33 of 2022 under section 7 within bracket small a, the PC Act 1988. So, petitioner was directed to submit his show cause reply. So, by another communication, on the same day, the salary of the writ petitioner was stopped. Subsequently, the petitioner obtained his bail from the court and a reply was also filed dated 23rd of September 2022. Stop. It is the submission of the petitioner that in spite of notices being served on the petitioner to appear before the authorities concerned in connection with the hearing and despite the petitioner having appeared, to the best of the knowledge of the writ petitioner, the proceedings did not conclude and no specific order was passed. So, the petitioner submitted his representations, which remained seeking redressal, on which also no specific orders were issued. Stop. Being agreed, the present petition has been filed. There. Mr. Nayak, petitioner lady for the state, referring to the affidavits filed, submits that the contention of the counsel for the petitioner is incorrect. As pursuant to the show cause notice issue, the petitioner was served with notices to appear, and however, the petitioner failed to avail the opportunities granted. And as a consequence thereof, the inquiry was completed and the inquiry report was submitted. This means this averment, Mr. Nayak has drawn the attention of the court to such specific averments, maybe para.
Page 122, Lordship.
At page 122 of the additional affidavit, is it?
Yes, last paragraph 3, last paragraph, sub-paragraph.
Para 3 at page 122 of the additional affidavit filed on 5th of June 2025. So, Mr. Nayak, referring to the averment, submits that after submission of the inquiry report, the petitioner was granted an opportunity to represent his side, and which opportunity the petitioner preferred not to utilize. So, the petitioner in turn has also filed his rejoinder affidavit, where he has denied the averments made in para 3, and according to the petitioner, there was no intimation made to the petitioner regarding any findings of the inquiry or the disciplinary proceedings, and no formal order or closure report has been issued by against the proceedings, nor was a copy provided to him. So, the learned counsel for the petitioner maintains that, as per instructions, he was never served with a copy of the closure report or the inquiry report, and therefore, the petitioner is not aware of the status of the inquiry proceedings. Stop. Considering that the submissions made, in order to proceed further in the matter, it is necessary to call for the relevant records of the department to examine whether the status of the inquiry proceedings initiated against the petitioner, and whether the inquiry report was submitted, and also further as to whether a copy thereof was served on the writ petitioner. Let the records be placed before the court on 21st August. Yes. Released on 21st. Only let us see the reports.
Online.
My lord, in this case, hearing has already been done, my lord.
Yes.
Number of occasions, and the last time they have, say, a short time to file a reply to my additional affidavits. So one was filed on reply on 13/6, and second additional affidavit, they filed reply on 19/6. So they are disputing, my lord. So automatically just go to the arbitration, my lord. The law is very clear, my lord. We have placed all the judgments, my lord. I think 10 or 11 judgments we have submitted, my lord. And from the claim of they are supposed to get 12 crores from the sale of the garden, my lord. And it has gone to 15 crores, my lord, as per their own admission, my lord. So it definitely, my lord, it has to go to arbitration, my lord.
There is a dispute. There is no dispute that there is a dispute.
Yes.
The question is whether it will be in the domain of the NCLT or should it be referred to arbitration. That's the issue. So, proceedings were initiated earlier seeking arbitration. And
NCLT proceedings cannot come on the way, my lord.
Yes. Anything more to submit?
And this is the last order passed by NCLT, my lord.
What is the last order?
That nothing happened, my lord.
Your Lordship, it is not in my hand if nothing is happening. We are filing writ in several matters. We have filed writ for
No, we are asking you, is there anything further to be submitted? We are closing
Yes,
the
Your
hearing.
Lordship. Yes, Your Lordship.
Yes,
Actually, I
what-
have not
what-
even
what is it?
submitted, Your Lordship.
Huh?
I have not even submitted. I am having a lot to say in this matter, Your Lordship.
What is there lot to say? It's a question of whether the matter needs to be
No,
referred to arbitration.
apart from that, two other
There
issues
is no,
involved.
there is no dispute that there is an arbitration clause.
There is no dispute.
And the parties are having an issue which arises out of the contract.
Your Lordship.
Now,
Apart from
kindly
that,
take us to the contract. The
Your Lordship,
agreement.
before that, I need to apprise to a few additional facts.
No,
Because
first let
what
us
is the
understand
issue?
the contract. Let us
Yes,
understand
Your
the,
Lordship. What is the issue?
where
Issue
is the arbitration clause?
Number one,
7, my lord.
non-starter.
No,
This-
please address the court's
Yes,
queries.
Yes, Your Lordship.
Arbitration clause is at page 67.
Yes.
And this is arising out of a
Share purchase agreement.
share purchase agreement. Now, what is before the NCLT?
They have filed
Oh.
operation and mismanagement. But I am the shareholder of the company.
No,
I've produced that original certificate, share certificate also.
that is further
They have-
petition
they
is
have
already
signed.
there. I have dealt in my reply as well.
Now, if this is an agreement where there is an arbitration clause and a
Yes.
dispute arises, where is the bar for the arbitrator not to decide on these issues?
Right, Your Lordship. Now, there are 2-3 aspects which need to be considered. This petition is non-starter. The petition has been filed on the basis of apprehension and assumption, number one, from the side of the petitioner. Number
No, how
two,
much time are you going to take, Mr. Counsel?
Your Lordship, at least 45-50 minutes for the
All right,
facts, and
then-
I'll take 20-25 minutes for the judgment.
Then you
And-
come back for a physical hearing. We can't continue for 45 minutes on the virtual mode.
Lordship, kind. Sir.
Mr. J. Roy, Senior Counsel for the petitioner, and Mr. Kesari, Alternate Counsel for the respondent. Mr. Kesari submits that you'd like to address the court on certain issues. And it is submitted that it requires at least 45 minutes to address the court, considering the fact that Mr. Kesari is on virtual mode and elongated hearing is necessary. The matter as per the council. Court considers it appropriate to fix it on another date for a physical hearing. Tell us. 21st August.
My lord,
Yes, Your Lord. Fine.
25th August. 25th. 21st, I am out of state.
25th is not then 28th of August.
Yes, ma'am.
28th of August. Release this matter on 28th of August.
Your Lordship, 28, the same matter is before Calcutta NCLT, Your Lordship. If Your Lordship then consider 26th or 24th or any day after 28. 26, 24 or any day after 28, subject to